All rise. Benton Circuit Court now in session, the Honorable David L. Williams presiding. Make sure your cell phones are turned off. Bow your head for a moment silence. Everybody may be seated.
Commonwealth versus Spencer Altman. Good morning. Are you Spencer Altman? Yes. Althouse, I said Altman. Spencer Althouse. Is your year of birth 1989?
Yes, sir.
Last four digits, social security number
Yes.
8324. Okay, what does the Commonwealth have to say?
My
You want
understanding,
to come around where it's on camera?
I understand what the man football has to have an evaluation. I am, Your Honor.
You gonna submit any reorder? That'll be fine. They're gonna take a look at you, Spencer, and we'll do an evaluation on it. Cooperate with them, okay? Thank you.
Thank you.
Daniel Anderson. Commonwealth versus Daniel Anderson, 25 CR 0055 and 25 CR 00113. Are you Daniel Anderson?
Yes.
Good morning. You born in 1988? Yes. Last four digits, social security number 1882.
Yep.
You're here on a pretrial diversion revocation and a pretrial conference. What does the Commonwealth have? So you stand a little bit to your left there.
We got a felony plea.
Daniel, I understand that you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person we just identified in 25 CR 0055 and 25 CR 00113?
Yes, sir.
Okay, is this plea freely and voluntarily given?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Okay, discuss this matter with your attorney. Is you satisfied with his advice?
Yes, sir.
Have you reviewed the evidence Commonwealth has against you? Then you're fully informed about your case. You understand? But you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept the plea, I need to know that you understand those rights. I'm going to go down through the rights. If anytime you have any questions, you can stand back and ask your attorney, okay? You have a right not to testify against yourself. No one can make you say anything. Your right to speak trial by jury. Your right to be represented by counsel at your jury trial. You have a right to be, you have a right to confront, cross-examine all witnesses called to testify against you. Right to produce evidence, right to call witnesses in favor, right to appeal this matter to higher court if you lose. You have a right to require the Commonwealth to prove on a reasonable doubt that you're guilty of the charge. You understand that by entering this guilty plea, you waive those rights. You understand that?
Yes, sir.
I may consider Commonwealth's recommendation, but I may apply a range of sentence, provided the law, which might be, more strict. I don't have to accept the recommendation. Prior to accepting the recommendation, however, I will waive pre-sentence probation and parole. In the event that I decide to give a more harsh punishment, you have the right to withdraw your plea. You understand that?
Yes,
Stand to the left just a little bit. Mr. Stockton, are you presenting the Commonwealth?
I am. Your Honor, Mr. Anderson would plead guilty to disposal of property other than his at a site facility prohibited, sentence of 5 years, receiving stolen property over $1,000, a sentence of 5 years, theft of motor vehicle registration plate, a theft of 5 years, all shall run concurrently for a total of 5 years, probated for 5 years, supervised. He's currently incarcerated and shall serve an additional 90 days in jail after final sentencing. The 5-year sentences shall run consecutive with Clinton indictment number 25 CR 55. He'll pay restitution in the amount of $1,344 at the rate of $100 a month, beginning on June 11th, 2026, and each month thereafter. And he'll remain on active supervision until all restitution and fees are paid in full. He'll also be assessed for the Clinton County Specialty Court Program and shall be required to complete that program.
Is that what you agreed to, Mr. Anderson?
Yes.
Counselor, he's also stipulating, pretrial diversion.
That's correct.
Okay. Okay, well, I'll accept the plea and schedule sentencing on February the 12th.
That's your signature.
And there was an order in lieu of revocation. What's it say?
Got a drug court. And we were.
Yeah, that may have been a mistake. It'd probably be better if we just go ahead and revoke these diversion and then put him in the specialty court.
Okay, thank you very much. You're finished. I'll take a look at court costs and what you're doing there. Christopher Burkett. Caldwell versus Christopher Burkett, 25 CR 0077. Are you Christopher Burkett?
Yes.
Good morning. This is 25 CR 0077. Mr. Burkett, were you born in 1962? Last 4 digits, social security number 9537.
No.
We're on a pretrial conference right now.
Your Honor, I've made an offer and there's also an underlying case that's pending.
Mr. Burkett, you step to the left, we'll do.
That may be presented to the grand jury, but I've not made a decision on it because I'm waiting on that.
What is your negotiation day next week?
February the 2nd at 1 p.m.
Okay, we'll continue this case till February the 12th and have a negotiation day on February the 2nd. And Mr. Burkett, if they have additional charges, that way they can bring it up and you try to get all wrapped up at the same time, okay? Okay. Okay, thank you very much. Cromwell versus Gary Flannery, 25 CR 0076. Are you Gary Flannery?
Yes, sir.
Good morning. Were you born in 1978?
Yes, sir.
Last 4 digits, social security number 5544.
Yes, sir.
You're for pretrial conference on 25 CR 0076. What does the Commonwealth have to say?
We've made an offer and we've proved that we've identified him. I guess what you want to do in this case. You ready for trial?
made a counter offer.
That's right. I need to get with the EMS people and see if we can pass this one in negotiation.
Negotiation day on February the 2nd. Next court appearance, February the 12th.
Thank you.
Okay. Commonwealth versus James Shelton, 25 CR 0097.
Given to Marion County, referred to Taylor County.
Are you James Shelton?
Yes, sir.
Good morning. Mr. Shelton, were you born in 1963?
Yes, sir.
Last 4 digits, social security number 8382.
Yes, sir.
You're here for a pretrial conference. What does the Commonwealth have to say?
I believe there's evidence that council needs to review. I know didn't think he'd be here this year, so there's evidence now he needs to review so we can proceed with this case.
Okay, well, what they're telling you is, Mr. Shelton, is in order to properly prepare your case, when you give your attorney more time to review the evidence that they have. Okay, so we'll set a negotiation day up on February 6th. Your attorney will be to see you before then to help him plan for that and get ready. And then you'll be back here in court on February 12th, okay? Thank you very much.
Thank you.
Commonwealth versus Wendell Shelton. Commonwealth versus Wendell Shelton, 25 CR 0093. Are you Wendell Shelton?
Yes.
Good morning. Were you born in 1978?
Yeah.
Last four digits, social security number 2766.
Yeah.
Okay, you're here for a pretrial conference. What's the Commonwealth have to say?
Mr. Rutherford needs to schedule a time to watch the CAC interview in this case. And if we can do that before the second, we can have a negotiation.
Can you work that in to meet with your client and review that?
I can, right.
They need that time to prepare your defense, sir. Okay? February 2nd is negotiation day, and February 12th, maybe you can wrap that up. Thank you.
Thank you.
Justin Smith. Commonwealth versus Justin Smith. 25 CR 00120. Are you Justin Smith?
Yes, sir.
Good morning. Morning, born in 1976.
Yes, sir.
Last four digits, social security number 5761.
Yes, sir.
What does the Commonwealth have to say in this case?
I believe Mr. Smith wants to trial.
That's correct.
What is the charge?
It's the PFO, burglary. Now, I will tell the court that his co-defendant's not been apprehended, so we may end up trying this case twice. Chief Nancy, I think Miss Goins, I don't know how to pronounce her last name. Yeah. Yeah,
Well, let's pick a trial date. You think this is a one-day trial?
yes.
And you're just back in the saddle again. You need some, when can you be ready for this case?
If we could get a day maybe in March. That would work for the Commonwealth.
What about March the 11th?
Fine, thank you.
That works for me.
So you want a pretrial on February the 12th?
Yes, sir.
Three 12.
11. Got the doctor lined up on my.
Thank you.
Taylor, is that correct? Come over, it's Michael Taylor. You are Michael Taylor? Yes, sir. Good morning. Good morning. Represented by Mr. Poindexter. Is your year of birth 1984?
Correct.
Last four digits, social security number 2856.
Yes, sir.
Okay, now, we had a competency hearing scheduled, is that correct?
Yes, Your Honor, and I told my expert that I figured you put it towards the end of the docket.
Just got the psychologist from KCPC lined up at 11 a.m. And also, if your expert has a report, I'd like to get that so I can send it to our doctor to review that. We won't have to do it during the hearing.
I'm sorry, yes, sir.
Okay, well, you facilitate that, we'll call it back up later.
Yes, sir.
Commonwealth versus Robert Wright. Twenty CR 0070 for probation revocation, 25 CR 0072 for a pretrial trial. Are you Robert Wright?
Yes, Your Honor.
Good morning.
Good morning.
You were born in 1981.
Yes, sir.
Last four digits, social security number 6136.
Yes, Your Honor.
What's the Commonwealth have to say?
Well, we have a felony plea, Your Honor. That's correct.
Okay. Hold on. Mr. Wright, you just been informed of the motion that says you wish to enter a plea in this case. Is that correct?
Yes, Your
Are
Honor.
you currently under the influence of drugs or alcohol?
No, Your Honor.
Is this plea freely and voluntarily given?
Yes, Your Honor.
You're the person we just identified in these two cases, 20 CR 0070 and 25 CR 0072. Is that
Yes, Your
correct?
Honor.
Is your judgment impaired today in any way?
No, Your Honor.
Have you discussed these charges with your attorney and are you satisfied with his advice?
Yes, Your Honor.
Have you viewed the evidence the Commonwealth has against you?
Yes, Your Honor.
You believe you're fully informed about your case?
Yes, Your
You
Honor.
understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky United States Constitution. Before I can accept a plea, in this case, I need to know that you understand those rights. I'm going to go over the rights. Anytime you have any questions, step away and ask your attorney, okay? You have a right to not testify against yourself. No one can make you say anything. Right to speedy trial by jury, right to be represented by counsel at your jury trial. The right to confirm and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor, right to appeal this matter at higher court if you lose, and right to part of the Commonwealth prove on a reasonable doubt that you're guilty charged against you. Understand that by entering a plea of guilty, that you give up all those rights. You understand that?
Yes, Your
I
Honor.
may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept any recommendation. Prior to accepting any recommendation, I will wait the pre-sentence investigation report during the probation parole. In the event that I do not accept the Commonwealth's recommendation, and decide to impose a harsher sentence, you have a right to withdraw your plea and proceed to trial. You understand that?
Yes, Your Honor.
Step to your left a little bit, Mr. Stockton, what's the Commonwealth's recommendation?
Your Honor, case number 25 CR 72. Mr. Wright would plead guilty, receive a 3-year sentence, probated for 5 years. He will enter and complete IOP classes. He would be released at final sentencing. Also, he would receive credit for time served, obtain gainful employment, or do community service and pay court costs at discretion of the court. The other case, 20 CR 70, the Commonwealth is just gonna let that case expire. He's been on probation so long, and he's been in jail now since July 25th of last year.
So you're gonna withdraw your
Motion on that case.
probation application. So
And yes, that's correct. But Your Honor, I know Ms. Rout wants to know if the court would consider going ahead and releasing him today.
No. Was it part of the agreement
That was the agreement.
to release him? I'm
I'm withdrawing the other case. That's 3 years you're gonna have to serve. So release to them?
There'll be a final sentence.
Is that your understanding of Commonwealth's recommendation?
Yes, Your Honor.
Okay, has anyone, including your attorney, offered you anything or any other benefit, or you plead guilty because you did commit the acts charged in the indictment?
Yes, Your Honor.
So of your own free will,
Yes, Your Honor.
knowing your constitutional rights to explain to you, is it still your desire to go forward and allow the court to fix your punishment in the range committed by law?
Yes, Your Honor.
You understand, after doing this guilty plea, any future convictions and sports range penalty, you understand that?
Yes, Your Honor.
Is that your signature on the motion?
Yes, Your Honor.
I'll accept it, or PSI schedule sentencing for February the 12th and allow you to be released on an ROR bond that you'll need to. Huh?
Just said it wasn't part
He said it was part of your,
The final, he'd be released at final sentence.
at final sentencing, okay, well, that's when it's gonna be at final sentencing. See how you misunderstood my question.
Thank you.
Okay. Okay, Commonwealth versus. Now, you just have one other person in custody back there, is that correct?
Yeah.
Yeah, and we're waiting on Mr. Say, so we'll go to the docket where people are here. Commonwealth versus April Collins. Are you April Collins?
Yes, Your
Good
Honor.
morning. You born in 1976,
Yes, Your Honor.
last 4 digits, social security number 6911.
good.
We're on 25 CR 00114. Okay, what's the Commonwealth have to say?
We have a pretrial diversion plea here.
Motion's been tendered, ma'am, that says you wish to include it. Is that correct?
I'm your
A motion has been tendered that says you wish to enter a plea today. Is that correct?
I hate to talk to my wife because I don't know anything about,
Okay, well, we'll pass over your case. We'll put you back on the docket. What's the situation here?
I don't know.
I'm sure.
She's got a DUI and she's got a possession case and she was going to enter a diversion plea and plead guilty with DUI is what I thought was going to happen.
We'll pass it into the doc.
Okay.
Commonwealth versus Christopher Braswell. This is 25 CR 0088. Are you Christopher Braswell?
Yes, sir.
Good morning. You born in 1999?
Yes, sir.
Last four digits, social security, 5737.
Yes, sir.
You're the pre-trial conference, you're represented by Mr. Poindexter, Douglas Commonwealth versus.
My understanding is he wants to trial date, Your Honor.
What's the charge?
It's sexual abuse.
You move over this way a little bit. Have you had a negotiation day on it?
We've had a couple heat exchanged. I've furnished additional evidence. I think, yeah, yes, sir, yeah.
We already have one trial scheduled for the week of that. I'm gonna be trying to move it yourself.
I don't know. I'm getting kind of full up. The big case to start in April. I may be wanting to, if we get too many more, start putting some later.
Well, I'm not, a sexual abuse case, I'm gonna go ahead and get priority first. So,
The other guys in jail, Mr. Smith, Mr. Pitton, we're trying February in jail. And the case Mr. Allen's gonna do this month, the guy's not, he's out of custody.
what about the
Plus, I've
trial?
got another 2-day trial in Wayne County, first, second on special prosecution.
What about the 10th and, we've got a trial schedule on the 10th and 11th of February. You think that will go?
Yes.
We've got one scheduled for the 24th of February. Do you think that will go?
Oh, which one is scheduled for the left?
Carver case.
No, that's the only criminal, that's the civil.
It's a civil case, okay.
One on the 24th, I believe.
You think the Pittman case will already stay? What kind of case is it?
That's a case where, that case was dismissed, originally without prejudice. We brought it back after you got a new strangulation case.
Okay,
The victim's coming, she's,
I got you.
should be here, she's told us.
Monroe County case, Connell versus Gillespie on that.
That is already,
So that they, so.
Which
I'll
one?
support it all up.
Yeah, we're clear that.
Are you clear that day?
What day is that? Or month? March 4th? I appear to be, yes, sir.
What's your trial schedule?
What kind of district court trial schedule?
You've been that problem all every person. There's one.
Well, let's go ahead and schedule for that day and see if it works out. This person's. This person, Chris. So we'll have a pretrial on February 12th.
Pre-trial February 12th.
Final pre-trial. Commonwealth versus Brett Carver.
Judge Elmer George for Brett.
Somebody needs to turn the camera off at the Pulaski County Jail. And Mr. George, you need to turn your camera on.
Judge, can you hear me?
I can hear you and I see you now.
Okay, sorry.
There's some kind of light flashing on you, the window behind you.
Okay,
Okay, you are Brett Carver,
Yes, sir.
born 1979.
No.
70 what? 76, okay. Note to change on the docket, last four digits, social security number 5893.
Yes, sir.
Here for pre-trial conference, was a Commonwealth have said.
Your Honor, I spoke with state police. They said they can have this investigation complete in 45 days. I would like to set a negotiation day and meet with Mr. George. I don't think I've ever discussed this case with him other than get it continued. And if that's a date that he can't be
You
there,
have
I
a
would like.
negotiation date in February? or
Yes, second at 1 p.m.
Negotiation,
can we do it a day other than February? 45 days they won't have their investigation complete. So I won't be able to discuss it effectively with my client.
what's your March negotiation date?
I don't have one set yet, so I just have to communicate with his office and see if we can set
Okay, well,
something.
they'll communicate with you, Mr. George, on what the March negotiation day, after they provided you discovery sufficient time to review it, okay?
That's fair enough. Just get a hold of me, Jesse. We'll reach an agreement on a date.
You what? Yeah, the pretrial would be March the 5th. The problem is that's a little early in March to get it. You know, so let's say it March the 5th, and if we haven't had a negotiation day or discovery, then we can reset it. March the 5th, conditional bond, be back.
Thank you, Judge. May I be excused?
Absolutely. Have a great day.
Same to you. See you, Jesse.
Commonwealth versus Shirley Canester. Canester.
No, no, have her sit down, she's got health issues.
Are you Shirley Canester? Good morning. This is 25 CR 0074. Were you born in 1950?
Yeah.
Last four digits, social security number 5060.
Yeah.
What does the Commonwealth have here?
Well, there's two issues, I think, Your Honor. Both, Mr. Crowell filed a motion to suppress, which we're ready to proceed on. He's also filed a motion to release the identity of the transactional informant that, was the basis of the search warrant. In the police report, Ms. Canancer, when she was being processed at the jail, basically accused a lady of being that informant and said she's gonna get it. So that we've got case law that basically says when an informant's been threatened and they're a reliable informant, the Commonwealth doesn't have to release their name. And that's our position at this time.
Her response, Your Honor, is that, of course, Ms. Knatzer made some sort of passing statement, which I don't think could be viewed as a direct threat, but
Unless it was about you or me.
I-
you know,
I
it
can
might be.
I can understand the Commonwealth's position. I just don't agree with it. However, the problem we have is A, this is a transactional witness. B, this case can't be tried unless we have that individual's name. C, we can't have an effective hearing regarding the search warrant because credibility and the subsequent investigation after the report is received are the two major issues. You know, did the officer was he proceeding in good faith based on a reasonable foundation that he had to obtain the search warrant? Now,
You know, we frequently have hearings where they say that it was a reliable person if they've previously had the information from them before, that's without revealing.
well, possibly, we don't know what we're going to
I
get
know
into.
it's possible.
It's possible, but you know, if it's somebody somebody's just a snitch out there, that's correct. We don't know. We have an idea of who this is. Now, here's the other thing. There's probably some sensitivity to things like this, and if we have a hearing on this, it might be good to do it off camera and
What's the
perhaps,
sensitivity?
well, when you start talking about people who report people for possession or sale of drugs or
That's
whatever.
why Mr. Stockton doesn't want to reveal it.
Well, especially when Mr. Nancer names a name that she wouldn't want to give. I mean, that's not giving her a Christmas gift.
Well, is that who it is? I mean,
Well, I'm not gonna confirm or deny that, but she gave the name, so, and she said she's gonna
But
give
the
it
only
out.
thing that would have changed with, the only thing that would have changed with the threat would be the name.
Your Honor, I want to
Okay,
take this up.
when are you gonna be ready to have this suppression hearing?
Well, you got the witness here today, the officer.
Well, let's see what develops. We'll have the suppression hearing, see what develops.
When do you want that?
Let's do it now.
That's.
Yes, ma'am.
Let's roll her over. You will call your witness, Mr. Stockton? You want to come up here? Will you raise your right hand? You swear the testimony that gives the truth, and whole truth, and nothing but the truth.
Yes, sir.
Okay, state your name.
Thomas Pendergrass.
You got to speak up right to the microphone. And who you employed with in what capacity?
As of now, I'm employed with the Pickett County Sheriff's Office in Tennessee as a deputy sheriff.
Here, Judge, I'm trying to do three things at once. Not doing any of it very well right now.
You want to pass this to the end of the docket, so.
Now, let me get my thoughts. Officer Pendergrass, where are you employed now?
The Pickett County Sheriff's Office,
In
Tennessee.
Tennessee, back in July of 2025, where were you employed?
The Clinton County Sheriff's Office here in Kentucky.
Were you one of the officers involved in the search of the home of Shirley Canasta?
Yes, sir.
Without naming any names, tell the court how that search developed and
The initial search developed from a search warrant that we were able to obtain.
You need to speak up.
Sorry, sir. The initial search derived from a search warrant that we were able to obtain.
did you have anything to do with obtaining the search warrant?
Yes, sir, I was present.
All right, did the
Information
search,
was-
did the information that was in the search warrant flow from an arrest that you all had made that prior to the search?
Yes,
Without naming the individual, what was the nature of the arrest?
it was a traffic stop with the arrest for the driver for DUI and possession of methamphetamine.
All right, and what did you learn from that defendant that led you to get a search?
I had learned from that defendant that they had just previously to the traffic stop purchased the methamphetamine at the residence of Shirley Canasta.
I mean, did the person telling you this give an address?
Yes, they did.
Did that person provide you with any further information as to drug purchases that he or she had made at that address? in the past?
Not in the past, sir. Just the events of that night.
Was the sheriff present when that arrest was made?
The sheriff was not present.
No, not at that time.
No, sir.
Who prepared the affidavit for the search warrant?
I can't recall if it was Michael Raines or his assistant, Angela.
Were you the officer that swore to the search warrant?
Yes, sir.
You look, I'd like to approach your honor. Look at this document and tell me what you think, believe that to be. And I think that is, yeah,
If that is, believe be part of the affidavit, the search warrant.
all right, and that was, and you are the affiant in that, you were the one. Would you read that to the court?
Not in your head will not get it. That's a voice activated microphone.
Yes, sir.
Just read what the affidavit that you filed with the district court asking for a search.
This says, acting on the information received, affiant conducted the following independent investigation. Through investigation, the affiant learned from the arrestee that she had just previously left the residence of 656 Cat and Mouse Road, Albany, Kentucky, 42602. The arrestee stated that while at the residence, she snorted a line of dope and took 2 hits off of a meth pipe. The arrestee stated that the substance she used was given to her by the residents of 656 Cat and Mouse Road, Albany, Kentucky, 42602. The arrestee further stated that this residence is a place she frequently goes to get drugs.
Now, were you present when the officers actually went to Mrs. Canaster's house
Yes, sir.
and conducted the actual search? Who else was there? What other officers?
Deputy Christian Markham with the Clinton County Sheriff's Office, Officer Parker Hickman with the Albany Police Department, as well as Trooper Brandon Poole with the Kentucky State Police, and myself.
Did you hear Mrs. Canaster make any statements during or at the conclusion of the search?
Yes, there were.
Did she make any statements about who she thought the informant was that turned her in?
Yes.
What did she say about that individual?
Can I refer to my citation?
Yes, sir.
Says during casual conversation at the PD, which would be the police department, Canaster stated that she thought Diane Smith had turned her in and stated that she was going to get it.
Well, Diane Smith actually was not the informant. Is that correct? Without telling who was.
Correct.
So at that time, Ms. Canester made it a threat. It showed that she was going to get the informant, whoever she thought it was.
Object, Your Honor, that's leading and that's not what was said.
Well, I sustain the objection to the.
Well, Judge, it's the position of the Commonwealth that we do not have to give
Let's just
the,
finish with the question.
I'm through with him, I'm through with this gentleman.
Deputy Pendergrass, I do have some questions for you, sir.
Yes, sir.
So this individual that, was subject to the traffic stop, was this an individual you were familiar with?
Yes, it was.
Okay, and what had been your, the basis of your familiarity with that individual?
Prior arrests.
Okay, is that the only, dealings you'd had with that individual?
Yes, sir.
Did the prior arrest deal with anything regarding, honesty or veracity, or were they simply drug or DUI?
Judge, I don't even understand the question, I object to
Well,
that.
I'll rephrase it. Do you recall what the nature of the previous arrests were, sir?
I can't exactly recall.
Were they drug related or do you know?
I can't recall.
Okay. Now, specifically, the information that you received was that there was methamphetamine at that residence. And in fact, when you conducted the search, no methamphetamine was found. Is that correct?
That's correct.
And do you know what the ultimate disposition of the case was involving the informant? You know, if she pled guilty or was convicted?
The informant, that was not my case.
Okay.
Thank you.
Okay. Okay. Who was involved in that traffic stop with you?
Myself and Officer Parker Hickman from the Albany Police Department, as well as Trooper Brandon Poole was present toward the end of the stop.
Where did that traffic stop occur?
It occurred at the intersection of Allen Street and it was at the end of Allen Street. I cannot recall the other road that
Okay.
intersected it.
One end of Allen or the other. Allen Street be about 2 miles from this location where Miss Canatra lives. Is that correct?
Approximately 2 miles.
So it would not be in the immediate vicinity, correct?
That's correct.
And you did not see
2
this
miles.
vehicle, observe this vehicle leave from the residence of Miss Canatra. Is that correct?
That is correct.
And you had no other information other than what this informant told you that this vehicle had been to the Canatra residence. Is that correct?
I believe that is correct. Yes.
Okay. Now, your affidavit states that you received information to traffic stop. First of all, the traffic stop, you had a search and found a plastic bag of white powder substance. The substance field tested positive for methamphetamine. That's correct, right?
That's correct. Yes,
Okay. Now, below that in your affidavit, it says acting on the information received. Now, I'm not understanding how this information, what information was received by you before we get into this so-called independent investigation?
Can I refer to mine?
Yes, you may, sir.
Right here, on this page.
Yes, I have it. That's what I have pulled up. But I'm not wanting to get into the second part. I'm wanting to get into the part above that. What information was received other than you found meth on this informant?
That they had previously left the residence of 656
But
Cadmus
that
Road.
says,
Well, I didn't finish his answer.
I'm sorry, please finish your answer.
Sir. And that arrestee, while I was at the residence, used methamphetamine. That was the information that we were
Okay.
talking.
So what you're stating to this court is that that was the so-called following independent investigation, correct?
Be correct?
Okay. But it's what happened, and I'm trying to figure this out. You stopped this individual and found meth, correct?
I did not stop the individual.
Okay, so you were with some people that did.
Yes, sir.
Methamphetamine was found, correct?
That's correct.
At that point in time, there was information either volunteered or responded to by questioning that I got this meth at 656 Cat and Mouse Road or Shirley Canatras, whatever. Is that correct?
That's correct.
Okay, now, after you received that information, what independent investigation did you do?
We acted on that information.
Okay, so am I correct? And there was no independent investigation by you, or as far as you know, by any of these officers after this defendant, after this informant told you this information, correct?
There was questioning to the informant for validity, that
But that's all at the time.
Let him answer his question.
that substances would be there. We then took that information to the county attorney, then a search warrant was.
But what I'm asking is, after you got this information from her that said she'd been to a house 2 miles, what other independent investigation was conducted, if any?
That is all.
Okay. And the only dealings that I've had with this individual before is prior arrests, correct?
Correct.
Would that affect your determination as to the credibility of an informant if you'd arrested them before?
No, sir. I believe that they were telling me the truth at the time.
You believe they were telling you the truth, but no methamphetamine was found, was it?
That's correct.
Okay. I have no further questions.
Actually, according to your affidavit that you read just a moment ago, the arrestee in that incident said that she snorted a line of dope and took 2 hits of meth. Is that correct?
That's correct.
Now, was the address that the arrestee gave you the address of Mrs. Coniston?
Yes, sir.
And you all went, after you went to, where did you get the search warrant?
The county attorney's office.
Let me ask a question here. How long did the person you arrested say it had been since they had been to this residence that y'all had been searched?
Sir, we were told that it was directly like previous to the stop.
How long after you got the search warrant did it take you to go to the address that was given?
Approximately 30 minutes.
Same
From
night?
the signing, yes, sir. The signing of the search warrant.
And exactly what did your return show that you found there that night?
Can I refer to my,
Yeah,
there's approximately $9,058 in cash. That was in multiple dominations and bags and some bills of lading.
where was that located?
This was all, this part was all found in a safe, in a bedroom to the left of the house. It was, believed to be Shirley Canancer's bedroom. Also, she stated to us, that was her bedroom.
When you say she stated it was her
Miss
bedroom,
Canancer, Shirley Canancer.
is
stated
the
to
lady
us.
sitting here?
Yes, sir.
What else, if anything, what else was found?
There was 51 dosage units of a white oblong pill with the inscription M523, was in a clear plastic bag. That came back to be oxys, 10 milligrams. There was 50 dosage units of a yellow round pill with the inscription 230. It was in a clear plastic bag. That was also oxy, 10 milligrams. There were 6 clear bags containing suspected marijuana that had a total approximate amount of 25.65 grams. There was also 9 pill bottles containing different types of legend drugs. The majority of it was tizanidine.
To find anything else related to drug activity?
Not in that room, sir. That was all. in
The
that room.
return I'm looking at, Mr. Cross. Do you have the return or a copy of the return in your records?
I don't think so, sir.
You know who prepared the return?
That was me. That was.
Right. So when I ask you if there's anything else other than the pills that you described,
Okay.
did you find any drug paraphernalia?
There were, various pops, and then there were 2 digital scales.
You found digital scales?
Yes, sir.
Sure, someone got that really detailed.
You're picking up on the microphone. You're picking up on the.
All of this witness stuff.
Okay, you have anything else?
Now, Deputy Pendergrass, the return says, quote, various drug paraphernalia, close quote. Did you itemize or particularize what you said were pipes found?
There were just multiple pops that were collected. That was all.
And when you say pipes, what kind of pipes do you mean, sir?
Pipes used to smoke substances.
Were these in the safe? Were these found in the safe?
No, that was not in the safe.
Okay. You know who was living at the Canatzer residence?
Shirley Canancer, Tawny Canancer was there. There was also a juvenile, male. And also they had said that, I believe it was a grandson, was also staying there, but he was not present at the time for the search warrant.
Now, the safe was locked, correct?
Yes, sir.
Okay. Now, let's go back to the initial traffic stop regarding the informant. The informant didn't say 656 Cat and Mouse Road, did they?
That's correct.
What did they say? What did they refer?
Shirley Canancer's house.
Okay. And did they specifically refer to Shirley Canatzer or just say Shirley Canatzer's house?
They said Shirley Canancer's house, and when I further questioned them about where, they said it was on Cat and Mouse Road. They were able to describe the house and which side of the road it was on.
Now, when you and the other officers obtained this information, did you all have a discussion amongst yourselves how next to proceed?
Yes, sir.
Okay.
It was a mutual.
What was the nature and substance of that conversation, sir?
I can't exactly recall. It's been almost
Now,
a
Officer
year.
Pendergrass, you're not a native of Clinton County, are you?
No, sir.
And I believe you live in Tennessee now, correct?
Still live in Kentucky.
Okay. How long have you lived in Clinton?
Approximately 5 years.
Okay. But you didn't have any experience with this informant other than being involved in arrests prior to this night. Is that correct?
That's correct.
Did you discuss with Hickman, Poole, Markham, any of the other fellows of their prior experience or dealings with this informant?
I can't exactly recall if I did or not.
So based on what you can recall today, no one in that group indicated they had previous, rephrase that. No one had any basis for believing that this individual was reliable based on any prior dealings with it. Is that correct?
I can't recall the conversations that we had.
So you can't remember anybody saying, oh, I believe her, she's told me stuff before or anything like that? No conversation regarding that?
I can't recall, and I wouldn't,
Okay.
I wouldn't want to say I did, and It's been so long, I
If
can't
you don't
recall the
remember, it,
conversation
you
that
just
we
don't,
had.
you know, you can't recall.
It wasn't
Thank you.
citation.
That's all I had.
In the conversations that you had following the arrest on a traffic violation, Mr. Cross asked you about conversations that you might have had with Sheriff Markham and who is it, Officer Hickman?
Sheriff Markham wasn't involved.
Who else was there?
Well, I know who was there. You know, there's a state trooper, city police officer.
Officer Poole. Did anybody indicate to you that they recognize that address to be in a high drug traffic area?
Yes, sir, we all knew that that was a high drug trafficking area.
So there was some investigation made other than just relying on what the individual told you.
Yes. Just prior knowledge, knowing of that area.
That it was a high traffic
Yes,
area.
yes, sir.
Great.
But the affidavit says you conducted, quote, following independent investigation, close quote. And you just simply had some knowledge, some reports from somewhere that there may have been some drugs at the Comanche residence, correct?
Yes.
Okay. You didn't conduct any subsequent investigation.
That's
correct?
already been asked and answered multiple times.
I understand.
Okay, thank you very much. You want to make your argument, Mr.
Your Honor, I'm through with Deputy Pendergrass. I do want to address the court regarding the name of the
I'm
informant.
not going to give you a name.
Your Honor, I understand that at this point in time, but I wanted to address the court and move to do something. I would
Your
move,
motion.
Yeah.
You got it.
I would-
You
I would-
deserved it.
I would move that the name be furnished to the court in camera and divulged to counsel for the defendant so I can make my own investigation of this individual and the prior criminal charges that they've had in order to help gauge and determine the reliability. The basis of this is we've heard that he's had prior dealings with her, but nobody had any informants. I just want to see what kind of record this gal's got, if it's a female. And I think that's appropriate. It's a safe way to do it.
Okay, Mr. Hunley, you want to make your argument on the validity of the search warrant?
As I understand the privilege law in Kentucky, it starts out that at the initial stages, they definitely is a privilege. The Commonwealth does not have to reveal the name.
I've already ruled on that. Okay.
I
I want to know about the validity of this search here. I want your ultimate argument. If you give the argument.
Well, I think the search judge is valid. You've heard the proof.
Tell me why you think it is.
Well, there's no reason to suspect that informant was telling anything but the truth. That
Well,
not,
let me do a Socratic method here. Okay. What, you got something?
No,
Okay, so what we have here is we have a stop of someone who is arrested.
That's correct.
They're charged. Upon interrogation of the individual, they say that in an approximate time, they've been to the defendant's house and used drugs there and bought drugs.
That's correct.
Okay. Now, and so they come get a search warrant, they go there and they find drugs there.
That's correct.
And then she makes a statement. She thinks she knows who it is, which would indicate to me that maybe there'd been another transaction
That's possible.
going
Your
on
Honor.
there.
That's
That's possible. And then they search and they find drug paraphernalia and they find drugs, multiple units of various drugs and that sort of. Now, tell me why that search is valid, or is that enough? Do they have to do any other prior investigation or reliability?
Well, you left out the most important thing, I think, Your Honor, is that all the officers there that night, when the girl gave them the address, recognized that to be a high traffic drug area. And,
Okay, now with that additional information, is that enough to sustain the search?
I think it very well could be.
Well, I know I'm gonna decide what it could be. I wanna know what the Commonwealth believes it is.
I don't see why it wouldn't be.
I want you to tell me, and you think the case law in Kentucky allows the search under the circumstances that were just related about you and something that.
Well, the case law is all over the place on these things, Judge. It depends on which case you pick out, but
Well, here's the thing. You're gonna have to tell me what you're relying on.
you want us to break the case.
I'm gonna ask Mr. Cross, you've heard what the Commonwealth had to say, and I don't believe it's necessary for you to respond to this juncture. And let's have the case brief, and we all agree on what the facts were. I stated the facts and you supplemented it with something that was crucial. So we will have briefs on the thing.
30 days, okay, Your Honor?
30 days is fine.
Thank you.
This officer be excused, you may be excused. Okay, thank you. We'll schedule this case to come back on February the 12th. February the 12th. Billy Davis Jr. Billy Davis Jr. Commonwealth versus Billy Davis Jr., 25 CR 0071. You are Billy Davis Jr.
Yes, sir.
Good morning. Were you born in 1970?
Yes, sir.
Last 4 digits of Social Security number 1524.
Yes, sir.
You're here today for sentencing. Had you have an opportunity to look for pre-sentence investigation boards on probation parole?
Yes, sir.
Is it substantially correct?
Yes, sir.
Counsel, is there any reason that this gentleman should not be sentenced?
No, Your Honor.
On a plea of guilty possession, upon plea of guilty, with failure to maintain insurance required by KRS Chapter 040, shall pay a fine of $500. Thank you so much. In cost, on plea of guilty possession of controlled substance, first degree methamphetamine, the defendant shall receive a sentence 3 years probation for 5 years. Further clinician, follow recommendation. She received critical time served and shall obtain gainful employment. All evidence is to be destroyed by agreement. Okay, now what is the total court cost? And then you got the $500 fine. $655. You need some time to pay it. Yeah, I allow you to pay it $60 a month. Okay, the first payment is due by 30 days from today. You'll need to meet with the probation and parole officer. Probation and parole ready to meet with him? Okay, thank you very much. Erica Decker. Are you Erica Decker?
Yes, sir.
You born in 1994?
Yes, sir.
Last 4 digits, your social security number 9876.
Yes, sir.
You're here on a pretrial conference in 25 CRs 0000103. Okay, correct? Okay. What does the Commonwealth have?
We have a diversion plea.
Okay. Okay, and we'll, after we finish this case, we'll immediately go to the 404B hearing in Stocking case, just to give the Commonwealth. It's a motion been tendered, ma'am, that says you wish to enter a guilty plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea all going to give it?
Yes, sir.
Are you the same person that we identified a few seconds ago in 25 CR 00103?
Yes, sir.
Is your judgment impaired today?
No, sir.
Have you discussed these matters with your attorney? Are you satisfied with his advice?
Yes, sir.
When you review the evidence the Commonwealth has against you, you believe you're fully informed about your case.
Yes, sir.
You understand that you do not have to enter a plea in this case. You have certain rights under the Kentucky United States Constitution before I can accept a plea.
Yes, sir.
I need to know that you understand that. I'm going to go down through them. If you have anything you'll ask your attorney, you step away and ask him. Okay, you have a right not to testify against yourself. No one can make you say anything. Right to speak trial, but you're going to be represented by counsel to your trial. right to confront possibly not witness call testify against you, right to be evidence, right to call witnesses in your favor. The right to appeal this matter to high court if you lose, or right to declare the Commonwealth proved on a reasonable doubt that you're guilty of the charge against you. Understand that by entering a guilty plea today, you give up all those rights.
Yes.
You consider the Commonwealth's recommendation, but I may also apply any range of sensible. I don't have to accept your recommendation. In the event that I do not accept the recommendation, I will decide to impose a harsher punishment. Now, I want to ask you some questions to see if you're eligible for pretrial diversion. Have you previously been diverted in the last 5 years?
No, sir.
Do you have any felonies in the past 10 years?
No,
Are
sir.
you currently on probation?
No, sir.
You understand that if you successfully complete the diversion agreement, the charges will be dismissed, pretrial diverted, you can have your record expunged.
Yes, sir.
But if you do not successfully complete the diversion program, you'll be brought back to this court. I can decide to set aside the diversion and schedule a sentencing hearing. And you be a convicted felon. Do you understand that?
Yes, sir.
Ms. Gordon Anderson, are you presenting the recommendation of the Commonwealth?
Your Honor.
Upon a plea of guilty to possession of controlled substance, first degree methamphetamine, the defendant shall receive a sentence of 3 years. Upon a plea of guilty to possession of controlled substance, first degree drug unspecified, the defendant shall receive a sentence of 3 years. The 2 3-year sentences shall run concurrently for a total of 3 years, pretrial diverted for 5 years, supervised. The defendant shall be referred to the social service clinician and follow any and all recommendations of the clinician. The defendant shall receive credit for time served. The defendant shall do a minimum of 30 hours per week of community service until gainful employment is obtained. The defendant agrees to have any and all evidence of both style cases disposed of in a manner that's consistent with the laws of the Commonwealth and the holding agency.
Is that what you agreed to do?
Yes, sir.
Are you pleading guilty because you did commit the acts charged in the indictment?
Yes, sir.
You're doing so of your own free will.
Yes, sir.
Knowing your constitutional rights, explain to us that still you desire to give up those rights and plead guilty to charges and allow the court to fix your punishment within a range permitted by law.
Yes, sir.
Is that your signature on the motion or?
Yes, sir.
Okay, well, I'll accept the agreement. She'll need to meet with probation and parole here. What are the fine and court costs?
It's $155.
$155. Do you need some time to pay that?
I can pay today.
I was gonna give you some time, but that's okay.
Okay.
You're very cooperative. So you can pay it today and you will need the probation parole. And I will, for the record's sake, that I did ride up on the elevator with this young lady and I didn't know she was gonna be in front of me today and we talked about the flu. But other than that, she didn't mention the fact she had anything in front of me. And I appreciate that you not mentioned it. I'm glad, I hope you don't have the flu. So we'll meet with the probation parole officer.
Thank you.
Okay, we're gonna go now and call the case of Commonwealth versus Nathan Stockton at 404B. You can sit over there. I think it's all witnesses.
You pass that, I'm following number, you still talking this. I'm Matthew Stein.
Okay. We'll pass it and call you back up. I want to do the admonition here. If you are watching this proceeding on YouTube and you're on the jury, you should immediately disconnect and I will inquire during board diary if we have a trial in this case. Well, then you proceed. So if you are violating your oath as a juror, if you listen to this or talk to anybody about it next year. Okay, let's go with Amy Elliott then. Commonwealth versus Amy Elliott, 25 CR 00102. Are you Amy Elliott?
Yes, sir.
Good morning. Were you born in 1974?
Yes, sir.
Last 4 digits, social security number 4733. You're here for sentencing. And you had an opportunity to look at the pre-sentence investigation report, number probation and parole.
Yes,
Is it substantially correct?
yes,
On a plea of guilty, is there any reason why she shouldn't be sentenced?
No, Your Honor.
On a plea of guilty, possession of controlled substance, first degree, first offense, the defendant shall receive a sentence. 3 years probated for 5 years. She shall enter and complete a long-term treatment facility determined to be scheduled by DPA, agreed on with the Commonwealth. Receive credit for time served. agree that any and all evidence should be dismissed. What's the court cost? $150. $150. You need some time to do that?
Please.
$30 a month, first payment, due 30 days from today. What about the long-term rehab? What's the deal?
But we have rescheduled. I got a bed letter for her last night,
Okay, when is the bid date?
tomorrow.
Tomorrow.
And
So you,
I'm going
when
with
you
that.
realize that when you go there, they're probably gonna test you. You're gonna be clean,
Yes.
or you're not hesitating. Okay. So you go there that long term and you stay there in the long term and you start paying your court costs 30 days after you're released from that. You do your first $30 payment, okay? Okay, thank you very much.
Thank you.
Kimberly Elmore. Howell versus Kimberly Elmore, 25 CR 00. Okay. You Kimberly Elmore,
Yes, sir.
okay.
Yes, sir.
Kimberly, have you been taking something? If I test you, you gonna be clean?
Yes, sir.
Yeah, well, we're gonna try it. You don't look like it to me.
I do know she had a partial stroke about a year or so ago.
Well, I know, and so I
Yes.
hope she's not taking anything. People that partial stroke still take drugs.
I think.
So, can you get somebody to test her? You go with this lady here.
Let's go with her.
Dusty Glidewell. I'm up versus Dusty Glidewell, 25 CR 0075. Are you Dusty Glidewell?
Yes, sir.
You born in 1989?
Yes, sir.
Good morning. The last four digits of your social security number 4526. Suppression motion to hold in abeyance. What's the story?
Well, after Mr. Gladwell was indicted, Mr. Cross began representation and filed a motion to suppress. After reviewing this case and Christopher Young's case, which is also on the docket, and also he is represented by Mr. Cross, I realized that Mr. Young is charged with possession of a handgun by a convicted felon. That gun was found at Mr. Gladwell's residence when the search warrant was executed. And Mr. Gladwell gave the statement that Christopher Young brought that gun to his residence. And he's the sole person putting that gun in Mr. Young's possession. So I cannot prosecute Mr. Gladwell until Mr. Young's case is disposed of. And I don't see how Mr. Cross can represent both parties, because what's going to happen is I'm going to call Mr. Gladwell as a witness in Mr. Young's case. And I don't know how Mr. Cross is going to properly cross-examine Mr. Gladwell. And if Mr. Gladwell decides, well, I'm going to change my statement, then that's going to be adverse to Mr. Gladwell's interest when I prosecute his case. So that's the conundrum we're in.
And Mr. Stockton, who sprang this on me only a day or two ago and informed me of some things I didn't know, may be right. He may not be right.
What
I
a
think,
concession for you to make.
well, it's, one of the best words in the English language is perhaps. And this is something I've got to, first of all, I've got to avoid having any conflict of interest. I represent both these young men. The
You might
cases
have to
I thought were
you might have
completely
to withdraw
unrelated.
from both.
Yeah, I don't know, perhaps.
Okay, well,
But
let's
if we pass it-
continue. Let's continue this case until February the 12th. And you need to have one or both of your clients there on February the 2nd for negotiations, if you're going to represent them or inform Mr. Stockton before then, and they can be present with new counsel on that day.
I'll have to meet with them independently,
Well, I
and I'll do
understand
that
that.
before then, and we'll be able to advise Mr.
So
Stockton.
you
where we
understand
think
that
we are. So-
your attorney's gonna see if he's got a conflict, and he'll tell you in plenty of time for you to get someone else to represent you, so you can be there on February 2nd. So February 2nd and February 12th for part of your bond. Melissa Gross. Melissa Gross. How much do you versus Melissa Gross? Are you Melissa Gross?
Yes, sir.
Good morning.
Good
You
morning.
Born in 1967.
Yes, sir.
The last four digits social security number 2738.
Yes.
We're here on 25 CR 0079 for a plea trial. What do we have?
A felony plea.
Okay.
I believe it's pre-trial for everything.
Yeah, it is. It's not.
A motion been tendered says you wish to enter a plea of guilty today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Yes.
Are you the same person we just identified in 25 CR 0079?
Yes. Yes.
Okay, this is a voice activated microphone, so you have to say something. Have you discussed, is your judgment impaired today in any way?
No, sir.
Have you discussed this matter with your attorney? Are you fully advised about your case?
Yes.
Have you viewed the evidence Commonwealth has against you and you believe you're fully informed? You
Yes.
understand that you do not have to enter a guilty plea today. That's correct. You understand that you have certain rights under the Kentucky United States Constitution. So before I can accept a degree, I need a plea. I need to know that you understand those rights.
Yes.
I'm going to go down through the rights. You have the right not to testify against yourself. No one can make you say anything. Your right to speed trial by jury, right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses, not testify against you. Right to produce evidence, right to call witnesses, right to fill this matter at a higher court if you lose, right to private commonwealth, put you on a reasonable doubt that you are guilty of charge against you. You understand that by entering guilty, you give up all those rights. You understand that?
Yes.
I may consider the Commonwealth's recommendation, but I may apply the range of sentence provided by law. I don't have to accept the recommendation. If that you would not accept the recommendation for the deliberation and decide to impose a harsher sentence, you have a right to withdraw your plea of guilty and proceed to trial. Understand that?
Yes, sir.
And I'm going to go down through some qualifying questions as to whether you're entitled to do a pretrial bail. You have previously been diverted in the last 5 years.
No.
Do you have any felonies in the past 10 years?
No.
Are you currently on probation?
No.
You understand that if you fully complete the diversion agreement, the charges will be dismissed and you can have your record expunged. You understand that?
Yes.
You understand that if you do not fully complete the diversion program, you'll be brought back before the court and for a scheduled sentencing hearing. You'll be a convicted felon. You understand that?
Yes, sir.
That can be used against you in the future.
Yes.
What is the Commonwealth's recommendation, Ms. Gordon Anderson?
Yes, Your Honor. Upon a plea of guilty to tampering with physical evidence, the defendant shall receive a sentence of 3 years. Upon a plea of guilty to possession of a controlled substance, first degree, first offense, the defendant shall receive a sentence of 3 years. The 2 3-year sentences shall run concurrently for a total of 3 years, serve 15 additional days in jail with balance, trial diverted for 3 years, supervised. The defendant shall be transferred to social service clinician and follow any and all recommendations of the clinician. Probation and parole shall arrange transportation to and from the office regarding report days. The defendant shall receive credit for time served. The defendant agrees to have any and all evidence in the above style cases disposed of in a manner that's consistent with the laws of the Commonwealth and the holding agency.
She said, is that what you agreed to, Ms. Groves?
Yes, sir.
Okay, now she was supposed to serve 15 more days.
That's correct.
Are you pleading guilty because you did commit the acts charged in the indictment as amended?
Yes.
Okay. You're pleading guilty of your own free will.
Yes.
I'm not asking you if you're happy about it, you know.
Right.
If it's your own free will. Knowing your constitutional rights, to explain to you, is it still your desire to give up those rights, enter plea of guilty to the charges and allow the court to fix your punishment in arrangement permitted by law? Is that your signature on the motion there?
Yes, it is.
Okay, I'll accept it. Now, when are these 15 days? Do they start today or does she need to turn herself in?
I'll leave that to the court.
Okay, are you prepared to go today?
No.
You have some, I mean, you're going today unless you have somebody to take your purse and take your stuff. So
No.
you have a family member that
I
can.
do have a family member, but she's not here.
Okay, well, I would say that you turn yourself in to the Clinton County jail. She'll have to be transported to the hospital.
You take her now,
Yeah.
We've got a jail number here.
You what?
We've got a jail number here.
Yeah, but they don't keep female prisoners here, so she'll have to be transferred. So I can have her turn herself in to the Russell County Jail.
Not that she'll have to go through Clinton County, be
turn across the
Or you process
Yeah.
it.
Then they'll take her.
Okay.
Yeah.
Okay, well, you turn yourself in to the Clinton County Jail by 2 o'clock today. That way they can transport within normal business hours, okay? 2 o'clock.
Okay.
And don't take anything or do anything between now and then. You come clean, okay?
Yes, absolutely.
Okay, thank you very much. What's the court cost here?
155.
$155, man. You got court costs $155. You pay that $30 a month, starting 30 days after your release from jail, okay? Thank you. Jamie Harold. Sentencing. Commonwealth of Kentucky versus Jamie Harold. You are Jamie Harold?
Yes, sir.
Good morning, Jamie.
Good morning.
You born in 1977, last 4 digits, social security number 3525. River Sentencing in 25 CR 0011. You had opportunity to look at the precinct's investigation for the probation parole. Is it substantially correct?
Yes, sir.
Okay. Is there any reason this gentleman should not be sentenced?
No, Your Honor.
Or plead guilty to failure to maintain insurance required by law, the defendant should pay $500 fine, cost of possession of controlled substance. The defendant shall receive a sentence of 3 years, while plead guilty to information indictment, wanton endangerment. First degree defendant shall receive a sentence of 5 years. The 3 years and the 5 years shall run consecutively until 8 years. Serve 60 days in jail with a balance probate for 5 years supervised. The 8-year sentence shall run consecutively with indictment number 24 CI 0081. The defendant shall complete the specialty court and shall first serve 60 days in jail, then be released from incarceration in the morning of special court orientation. What are the court costs in this case?
It'll be a total of 655.
$665, and you start paying $60 a month upon 30 days after your release from these 60 days, okay? Okay, so I guess you're in the custody of the jailer.
Yeah.
I didn't see that in there, so. Okay. Then you are served 6 days. Are you in drug court already? Oh, good. Well, he's capable. I've known Jamie since he was a very young man. He's always been a good worker. He's just on the edge of problems.
Yes, sir.
Well, maybe you can turn that around, Jamie.
I'm
Okay.
trying.
Okay.
Thank you.
Does he need to be with probation parole officer? Yeah, wait a second. Did you do the drug test? What did it show? Okay, well, we'll get on the record. Call her back up here. Kimberly Gilmore? Okay. Okay. Where's your? Poindexter. Poindexter.
Yes, sir.
Okay, we have a report in on the drug test. You come around. You raise your right hand, you swear every testimony about to give us the truth, the whole truth, nothing but the truth.
I do.
State your name
Christie.
and who you employed by.
Probation.
Did you, at the request of this court, did you conduct a drug test?
I did.
Tell us what the results are.
Results were positive for benzodiazepines, Suboxone, and amphetamines. There was a faint line for methamphetamines. And she says that she does have a prescription for Adderall, Klonopin, and Suboxone.
Okay. What's the Commonwealth's position?
Well, is there anything that you tested for that's not covered by a prescription?
I would have to look up to see what the Adderall. Shows her.
I don't know, I think Klonopin may be a benzo. And I know Adderall is controlled substance, but I don't know that it show up as amphetamine, not a pharmacist. But I guess we'd have to do is check and make sure she does have a prescription, what she says she has.
She stated to me that she has those prescriptions in her vehicle.
So.
I'll let her go out to her vehicle and bring in with Mr. Poindexter.
Okay.
And go out and bring, I'll give you time to gather some proof to come up to show that she's got prescriptions. even she has prescriptions, she still appears to me to be under the influence, but you say that she's a stroke victim, so. If she got prescriptions, we'll go ahead and proceed with the thing. But, if she doesn't, we'll take a different approach, okay?
And of course, I'll take the report that part of the sentencing today is a long-term drug rehab.
I understand.
Improve probation.
Yeah, and we might very well send her there, but I want to see if she's taking things other than prescription. But when someone comes here under the influence of illegal drugs and says they, I don't like that. It's not good.
I understand.
Okay, so I'll give you some time to gather that information.
Okay, thank you, Robert.
Yeah. Okay. Are we ready for the 404B yet, or we still need some more time? Norris, Nagel, active warrant, NCIC.
I believe he's been served and is incarcerated in Florida, but they haven't received a return, so it's still showing as.
Oh, yeah, yeah, that's where he was last located. He was supposed to come down
So y'all make sure that they hold it. Kyle Norris. We have Graves County Jail in Are you Kyle Norris?
Yes.
Good morning. Morning. This is 25 CR 00117. Were you born in 1988?
Yes.
Last four digits, social security number 9777.
Yes.
There for a pretrial conference. What do y'all have on Kyle Norris?
Well, Your Honor, there's a case going to the grand jury today, so I asked that he be set for the February negotiation day and furnish the discovery of Mr.
There might be a subsequent charge, what they're saying, there might be additional charge. So I'm gonna have you come back here on February the 2nd for negotiations, and at that time, they'll present that to you. And also on the 12th, you'll need to be here, both in conditions. Now, if there is a subsequent charge, is there any need for me to set an additional bond for him, or can he?
What is his current bond?
What is the bond? He came this time.
It's $10,000 cash.
Sorry.
That'd be sufficient. He just won't need, there'll need to be an additional bond for the condition not to be around that and from the Congress or any of her families.
You want to step away from the podium and talk to him for a second?
Yes, Your Honor.
That's,
Whitney claim.
what's the charge?
Oh.
Your Honor, we just ask that his current bond condition allow him to be around Whitney Claiborne, just no violent contact as opposed to no contact.
Yeah, the first charge is I think domestic violence and terroristic threat and maybe wanton endangerment. He allegedly discharged a firearm while he was arguing with Whitney Claiborne. She's outside, she's contacted my office wanting the bond condition demanded just no violent contact. She wants to have contact with Mr. Norris.
All of it is no violent contact, and no violent or violence is, no threatening behavior or violent contact.
And I guess my question is, are you just want to be able to converse with her on the phone, or you want to be able to live together, or what's the story?
Be together, I just don't want to be, yeah, there's no.
So is the victim's advocate talk to her?
She attempted to, I've talked to her. She called my office and I had a lengthy conversation with her. I don't want to get into her background too much, but she's distressed about Mr. Norris. Just put that out.
Yeah, I want Mr. Norris to stay here in the courtroom, and I want the victim's advocate or the Commonwealth detective to go outside and interview this lady.
Okay.
Outside of the presence.
Nurse has been moved. Brandon's gonna be the Christian.
Where is he on the board?
Thanks.
Commonwealth versus Brian Gross, who's now in the Christian County Jail. Correctional institution, excuse me.
We withdrew that motion, Your Honor.
Well, I know, but he's there and I want to tell him about it. There were several motions for shock probation that were filed, and you are on this motion.
I believe on those charges, he was released MRS. Is that correct, Mr. Gross?
Yes, sir.
So it's
And,
almost,
I'm being held on a convicted felon in possession of a handgun, which was dispensed in August.
yeah, there's some confusion on what's holding him now.
He was convicted by jury of 3 years on possession. The remaining charges, Mr. Gross is correct, he was dismissed.
Okay, so we have no need from him.
No, I don't know
So
why.
if we have any hold on him from Clinton Circuit Court, it needs to be withdrawn. Is
That's
that-
correct.
Okay. Okay. Okay, thank you very much. And Christian County, thank you for your cooperation. You may be excused. Thank you.
Thank you.
Okay, Seth Roberts. Is Pulaski County on there? Are you on there, Pulaski County? You'll be next after this case, Pulaski County. Commonwealth versus Seth Roberts, 25 CR 0035. Are you Seth Roberts?
Yes, sir.
Good morning. Good morning. You born in 1993.
That's correct.
The last 4 digits, social security number 0026.
Yes,
We're on 25 CR 0035.
yes.
What does the Commonwealth have to say about this?
We have a diversion plea.
Just been informed that you wish to enter a guilty plea today. Is that correct?
Yes,
Are
sir.
you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person that we just identified in 25 CR 0035?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Have you discussed these charges with your attorney and are you satisfied with his advice?
Yes, sir.
Have you viewed the evidence Commonwealth has against you, believe you're fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky United States Constitution. Before I can accept a plea, I need to know that you understand those rights.
I
You
understand.
have the right not to testify against yourself. No one can make you say anything. Right to speed trial by jury, right to be represented by counsel at your jury trial. Right to complain, possibly having all witnesses called to testify against you, right to produce evidence, right to call witnesses and have process issue. No way of doing this. You have a right to appeal this matter to higher court if you lose, and right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charge against you. Understand that by entering a guilty plea today, you give up all those rights. You understand that?
Yes, sir.
Okay, I may consider the Commonwealth's recommendation, but I may apply any range of sentence, but I will have to accept the recommendation. If it's that you do not accept the recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. You understand that?
Understood.
Have you previously been convicted in the past 5 years,
No, sir.
the past 10 years?
Oh, no.
You don't have a diversion the last 5 years,
No, sir.
not on probation.
No, sir.
You understand that if you complete the diversion, the charge will be dismissed pre-trial verdict.
Yes, sir.
You understand that if you do not fully complete diversion, you will be brought back before the court and the court will schedule a sentencing hearing. Is that right?
Yes, sir.
Ms. Gordon Anderson, you have a Commonwealth's recommendation?
Upon a plea of guilty to flagrant non-support, the defendant shall receive a sentence of 5 years, pre-trial diverted for 5 years supervised. The defendant shall pay child support each month in the amount of $212 to be applied towards the regular payment, plus an additional $125 to be applied towards arrearages, for a total monthly payment of $337. The first flagrant non-support payment shall be due on February 1st, 2026, and due on the same date thereafter. Supervision shall continue until all flagrant non-support is paid in full. All flagrant non-support should be paid in full by the 59th month of the diversionary period. The defendant shall receive credit for time served. The defendant shall do a minimum of 30 hours per week of community service until gainful employment is obtained. The defendant agrees to have any and all evidence the above style cases disposed of in a manner that's consistent with the laws of the Commonwealth and the holding agency.
Is that what you agreed to?
Yes, sir.
Now, if you successfully complete the diversion program, dismiss pretrial verdict. If you don't successfully complete, you're brought back in front of me. And I revoke the pretrial diversion and sentence you, that will be a felony conviction that can be used against you in the future. You understand that?
Yes, sir.
Are you pleading guilty because you did commit the acts charged in the indictment?
Yes, sir.
Doing so of your own free will.
Yes, sir.
And your constitutional rights explain to you, is it still your desire to proceed with your plea and allow the court to fix your punishment?
Yes, sir.
Is that your signature on the motion offer?
Yes, sir.
I accept the agreement, we'll sign the diversion order. I guess you have to give certain information, probation, and parole, is that correct? Okay, thank you very, what's the court call?
155.
155, and I'll let you, what are you supposed to pay a month?
It's 300
Three.
37, so I'll let you pay an additional $25 for the court cost, okay? Start at 30 days, when you're able to pay instead $25 too.
Yes, sir.
Okay, Jeremiah Shelton, well, wait, I guess I told, wait just a second, Shelton. I guess, is Pulaski County on there? Pulaski County, we'll go ahead and take you up if you're there. Commonwealth versus Eddie Jarvis, 25 CR 0064. It's Mr. Jarvis, who we're aware of, born in 1947. The last four digits, social security number is 7422. We have a pretrial conference.
Your Honor, I've spoken with the Commonwealth. We, after much work, we were able to find a facility. We paid the bed deposit. They're asking to send their nursing staff down tomorrow to Pulaski County.
Mr. Stockton, who's following this right here? Okay. Go ahead and tell me let's get to the point.
Yeah, the point is, Judge, the nurses are asking to come down tomorrow. We expect him to actually have a bed appointment once they talk to him next week. We would like to get an order to allow the nurses in tomorrow. Then we'd like to be able to do an agreed order to transfer him to the
What are we
facilities.
talking about? I don't.
The memory care unit.
They're wanting to transfer him from jail to a mental health facility that's supposedly locked down. And it's a condition of his bond, so we're waiting on the KCPC evaluation. And so he would stay there rather than in jail.
Are you in agreement with
I
that?
would be in agreement with that as long as he can't leave. If he leaves, it's a violation of the bond.
You
It's my
understand?
understanding, it's my understanding, that it's supposed to be kind of like the nursing home, there's a code and everything. He can't get out of the facility.
Yeah.
Where is this location?
Lexington, Preston Green is the name of the facility.
Okay, I'll sign an agreed order, and Mr. Jarvis, you realize if you leave that facility, you're gonna be charged with escape. You understand that? Are you with us, Mr. Jarvis?
You know, yours.
I don't think his microphone is turned on.
Don't worry, Judge, he's gonna turn it on.
It's on.
I'll just go and send an order.
Hey, hear me now?
Oh, yeah, I can hear you now.
Okay, yeah, I'm very ready to go to trial immediately or,
Wait.
whatever it takes.
That's not the question. The question is, we're gonna send you to a facility that will hold you there. If you leave there, you'll be charged with absconding or escape. You have to stay there and we'll get your trial, okay?
I understand what you're saying. I've heard about it from my daughter. I'm very hard of hearing, but
Okay.
I'm very anxious to take this thing to trial.
Wait a second. You understand that? That you can't leave the place, is that right? So I'll sign the order and we'll get you transferred. You ought to be much more comfortable over there till we get this evaluation done, okay? Thank you very much. Thank you, Pulaski County, for being of assistance. You may be excused. I don't have a clerk. You can send my staff lawyer.
Okay.
Just
I'll
email
send
it
it.
to see electronic form.
Okay.
Okay, thank you very much. Yeah. Okay, we ready for this hearing in 404B here?
Yes, Your Honor.
Okay, Okay, well, let's get the motion officially on the record here. The Commonwealth has filed a motion in the case of Commonwealth of Kentucky versus Nathan Stockton. Mr. Stockton is present with his counsel here today. And 404B to introduce at the trial other bad acts. Is that correct for the Commonwealth?
Yes,
Okay,
it is.
now you have a series of witnesses.
I have, yes.
Okay, now we need to call the witnesses, but I would assume that the defense would want the rule to apply to the witnesses. And so until they're called, we'll call them one by one and then call them out here. So who's the first witness?
Franklin Heatherly,
Franklin Heatherly. Okay.
and the second
Wait a second, we'll do them one at a time.
will be
Come
Tina
on
Russell.
up. Come on up here.
That's the two I have, Your Honor.
Right up here. Raise your right hand, sir. You swear the testimony is the truth, whole truth, and nothing but the truth. Have a seat there. There's a red microphone in front of you. Let's state your name and where you're from.
Franklin Heatherly from Monticello, Kentucky, former fire chief for Monticello Fire Department.
Do you know Brooks Eves?
I did not, and
You
his
were about-
family,
you knew
he
he
passed
was.
away long before I started, so. Steve Farrell was chief when I started the fire department.
Mr. Heatherly, where do you live and what is your occupation?
I live in Wayne County, Kentucky, and was the fire chief for Monticello Fire Department then. I'm now a firefighter for the city of Somerset and farm.
I'm going to turn your mind back to December of 2023. What position did you hold at that time?
Fire chief for the city of Monticello Fire Department.
At some point prior to that, did the city of Monticello acquire, or were they in the process of acquiring a federal grant for the construction of a rather sophisticated digital sign to be installed there at the fire department?
That is correct. We were awarded a grant from FEMA Department of Homeland Security for staffing for adequate fire and emergency response. And part of that was recruitment and retention. And part of that recruitment and retention portion was to install a digital LED sign.
Did you advertise for bids on this sign?
We did.
What you wanted?
We did according
Or
to
did you, let's back up. Did you have any relationship with the defendant who was doing business in Albany, Kentucky as Starline Signs?
Not prior to the goings on with this. The newspaper ran the article that we'd received the grant, and it did put in there that we would be purchasing an LED sign. And between the time that was the newspaper published that and we took bids.
Had you talked to him before?
Nathan, they had come by and to display or demonstrate their signs and their company and give us some material for their company before we
Did
received.
he bring you any drawings or proofs of what he could do for you?
He brought a sample sign on a trailer that was powered to show what it could do and how easy it was to change. And it was a small, I think it was maybe a 3x6 sign that was on a trailer from Think Sign or from wherever that to show us what their company could provide.
Were you satisfied with what he initially showed you on paper?
It was was what we were looking for, an LED sign.
Right. At some point then, shortly thereafter, did you advertise for bids?
We did and
What was
sometime in December.
Did he submit a bid?
Their company was the only one that submitted a bid.
All right, so he said, did you enter into a contract with him then?
Yes, we accepted his bid. The city council accepted the bid for him to produce, for their Starline signs to produce and install the LED sign and cabinet.
What was the amount of the bid?
20. Can I hold up?
fresh in your memory, was the bid total of $29,000?
$29,977.26.
Before awarding him the contract, what understanding, if any, did you have with him as to how this sign would be constructed? Who would construct it?
Yeah, I don't want to get into too much detail. I'm just asking if he followed through, that sort of thing.
Well,
Details.
it's not that simple, Your Honor.
Okay, go ahead and proceed. Go ahead and proceed.
Did you know who he intended to, was it? He wasn't gonna build this sign himself, is that correct?
He would build part of it
Part of it.
in-house,
But
and he would have to order parts of it.
It's a rather LED, sophisticated, computer-driven sign, is that correct?
That is what we had anticipated to receive.
And
a digital-
did he let you know who would be constructing
It was on the bid for, that it said Think Sign.
Think Sign,
That's-
which is a company, rather sophisticated company in Louisville, Kentucky, is that right?
I can't speak on their sophistication. I just know that's an LED. Apparently that's an LED. That's what was on the bid. That's who manufactured the sign, the LED part of the sign.
Now, did he insist upon a down payment from you?
That was part of the bid. And part of the acceptance of that, the terms or payment terms required are 75% down payment to start the order. 25%.
Why would you and City of Monticello pay 75% down on something?
That was considered normal in the business, according to, said that we had to do that
According to him.
he had told us that that was part of what they had to do to get the sign manufactured, because it's a completely custom sign that the company manufacturing the LED would not begin production until they had a down payment.
In fact, didn't he tell you, and wasn't your understanding was that he would take this down payment and pay it to Think Signs in Louisville? That upon payment of the required down payment, that they would put that sign on a production line?
It was the understanding that that down payment would start the process and we would have a sign being produced by Think Sign and it would come to us. So that's the understanding we had. It would.
So
That down payment.
with that understanding, you paid him in advance, $26,000?
Yes.
Now, after entering into that contract, how did the acquisition of the sign proceed?
Once we accepted the bid and it was into February, by the time city council did that and we wrote a check. I believe February 14th, the check was picked up by Stacy. I think was his wife. Part of the company, she had brought some materials by, some advertising materials by for us beforehand. She picked the check up on February 14th and we were told that that would start the process and they would get to us.
That was February 14th.
That was February 14th.
2024.
24. And then we continued, I continued following up periodically to see what the process was. and-
How were you following up with it?
Okay,
With text message.
We're not trying this case. Move on.
Judge, this,
I've got enough. I understand. You ordered a sign, he prepaid it, it didn't come. That's the essence of the testimony. Okay, let's move on.
basically, it didn't come, it still hasn't come.
Yes, sir.
Okay, that's good enough.
Did you begin to make inquiries about the sign?
Okay, I don't care what he did. I understand what the allegation is. Let's move on.
We received no sign.
You received no sign. Did you receive any reasons from him why you were
I
not
don't care.
there?
I don't care. I understand. Time frame. He still hasn't received sign. Go ahead.
Judge, Carla, this is a,
He can testify at trial. Okay.
did you later, much later, find out whether he had made a down payment on the sign to Think Signs of Louisville?
I did discover that no down payment had ever been made to Think Sign.
Did you later discover whether or not the sign had ever been put into production?
Think Son advised me that they never started the sign because they did not receive their down payment. Their
Oh.
payment.
You paid him $26,000 and there is no sign.
There was no sign from Starline Signs. Or Think Sign.
What was the last word you received from Mr. Stockton after inquiries?
The last message is November 18th, 24. He advised me he spoke with his attorney, his attorney did not want me to meet with anyone after what had happened. And he will not be, he said he would be returning our digital sign that he had and issuing a refund. I will not be meeting with anyone or discussing the issue further. Therefore, I did not make any further contact because he stated he did not want any contact.
Right. Did he tell you just go ahead and sue me?
In a previous text message, he said that, he said, if I'd rather, I could start a lawsuit or whatever he'd like to do with it in a previous message on,
But he never refunded you any money.
no.
Now, would you answer the next question?
Do you have any questions?
Yes, Your Honor. There's a few questions. So who did you initially communicate with about designing a sign?
Initially communicated.
Yeah, who did you communicate with? Mr. Stockton, or was it with someone else? Perhaps Stacy Stockton?
Stacy, she represented herself as Starline Signs and brought it, her and her husband, Nathan, were operating that company. So Starline Signs was it was irrelevant who, I didn't think there was any relevance of the person, but the business card for Starline Signs and the brochure for Starline Signs was given to me about the sign and about the interest in providing the sign, providing a bid for the sign.
Okay, and you said that they provided a bid for the sign. Can I ask you, why did you select their business?
That was the only bid that was submitted.
Let me ask you, did Mr. Stockton do any work on the sign?
Somewhere, and if you want an exact date, I can look it up. Do you want an exact date? Or towards the end of October or late October, they came by and dug a hole with some post hole diggers.
Mhm.
I had some measurements, pictures of it, about this big around and a couple feet deep. Put a metal pole in it and poured concrete in it, told me he'd be back in 2 weeks. He's gonna let the concrete cure, be back later that week or 2 weeks to install the sign because it was all ready. He had it ready at the shop waiting to be installed and he'd be back once the concrete set.
Okay.
Which didn't happen.
And you mentioned that he offered to refund the money to you. Is that correct?
He did.
Yeah. When did he offer that?
That was November. On November 15th, he said that he would refund, and when I told him I would be coming for a refund, he said he wouldn't there. I'd have to. You will have to wait until I return the signs. That he said he had the LED signs in his shop. He would have to return the signs to get his refund so he could refund us, but.
So he had mentioned that it would, take some time to get the refund back to you.
At that time, I had knowledge that the signs were not ever ordered. So I told him I would be coming to get the check and that, I also stated that I would have to see the signs that he was going to return to know that that was actually going to happen.
Mhm.
I was going to meet him at a shop and he declined to meet me at a shop at that point. And, he was getting an MRI that day. So that was on a Friday. I told him I'd come on Monday at 8:30. He told me that was fine. On Monday, I told him I'd be there at 8:30. At 7:55, he texted me about that he'd spoken with his attorney. He would not be, he would not meet with me, and he said he would be returning our digital sign and issuing a refund. And I will not be meeting anyone or discussing the issue further. And we still have not got a refund or any other communication.
That's all the questions I have currently.
Can this witness be excused?
Yes, sure.
Thank you for being here. If you recognize him, is this set for trial? Wait just a second, sir. If you get him subpoenaed to be here for the trial?
Yes, I do.
Okay, so he doesn't need to be recognized.
He doesn't be named.
All right, thank you, Greg. Yes.
Thank you.
Call your next witness.
Called Tina Russell.
Come on up here, ma'am, and witness stand. You raise your right hand and swear the testimony you got these be followed. Take a seat there, please. Lean toward the red microphone and use your outside voice. And tell us what your name is and where you're from.
My name is Tina Russell and I live in Russell County, but I own a business in Somerset.
What's the name and nature of your business?
I own Signorama in Somerset and we're a sign company.
Are you familiar with the defendant in this case, Mr. Nathan Stockton?
Yes, sir, I am.
Had you done business with him in the past?
Yes, sir, I have.
How long had you and Mr. Stockton done business with each other?
Since 2022.
Would you give the judge the,
Okay, wait just a second. The psychologist needs to turn the camera off until we call him.
Yeah, and Judge, you could tell Dr. Sparks that they're gonna stipulate competency, we're not gonna have a hearing, so.
Dr. Sparks, competency has been stipulated. You may be excused. Thank you for being present. Okay, thank you.
what was the nature of the relationship in the business that you did with Mr. Stockton?
So in the sign business, you sell, you can do different facets of it. I'm a seller of sign goods and also a contractor of sign goods. So I would sell goods to my clients and then I would contract work out to people like Nathan, sign companies that do installation and fabrication. There's little fabrication done in some sign shops because it's a lesser skill. A lot of people don't have it. So when you need cabinets built or letters fabricated, you subcontract that out for someone else that can do it for you. And that's the relationship that Nathan and I had. I was a well-established sign company and I would get sign jobs for my customers. I would go to him with the project that I had before me, show him what I needed to have built and where it needed to be installed and the type of installation that it was. And Nathan would provide me a price for the build of the product and the installation of the product.
When was the last contract that you had with Mr. Stockton?
The last contract that I had with him began in February of 2025. And I
Tell us about it.
removed myself from that in June. As customary, I sent Nathan an example of a sign that we were doing for a church and for a church. Mhm. It was Bethesda Community Fellowship in Russell Springs, Kentucky. I sent him the rendering for the sign and what the customer wanted. He replied to me with the price for the cabinet. And that's what things get attached to, or mounted onto. He would fabricate that for me, paint that for me. And then I would purchase the letters in the name of the church. I can purchase those from another vendor. I would purchase those and supply those to Nathan, and then he would attach them to the cabinet once it was built. The cabinet had a masonry structure on the bottom that would have to be assembled by a mason. I did not know a mason that was reputable. He said he did and that he could arrange that work.
How did the contract proceed?
I presented the price he gave me to the customer, the church, they approved the order. I let Nathan know that it was approved. He requires a 50% deposit to be paid on the construction of the materials and the installation, and I paid him that.
All right, now, that initial deposit, what was your understanding at that time and throughout your business that would be used for?
That deposit is used to procure the materials and supplies needed to fabricate the cabinet and begin production on the cabinet. Once the cabinet was built, then you would receive typically the remaining 50%.
Now, when you're talking about the cabinet and something being built, we're talking about a digital sign.
This sign is, I mean, it's just a different type of sign. It's not a digital sign per se. It's an LED sign.
Who would manufacture or build the sign?
He was agreed to build the sign for me for the price that he gave me.
Oh, he was in the business of building himself?
Yes, he fabricated the cabinet himself in his shop.
All right.
Yeah, he would provide that cabinet and then install the cabinet on the masonry base once the masonry base was completed.
So what happened?
Well, this was in February, second to fifth. The church wanted the sign installed by Easter, which was in April. And, we agreed that it could be done by April. And so I paid him the 50% deposit and he was to get, of course, whatever he needed to build the cabinet. A little bit of time had elapsed. We had some really rainy weather. The mason wasn't coming out to do the work, and he proposed to me that since we had a rainy spring, that he thought it would be best to go ahead and get the cabinet fully built and ready and leave it sitting in his shop.
So it wasn't ready by Easter?
Yeah, to leave it sitting in his shop.
And what happened next ensuing in the contract?
So I paid him the remainder of it, the cabinet in full.
How much was it?
All in all, $10,080. I paid him for that and began to ask where the cabinet was. Could I see photos of the cabinet? He would not provide photos for a long time. He did provide a photo through text message that he tried to pass off as the cabinet. I showed it to my other sign installer and neither one of us were in agreement that it was my cabinet.
So he sent you a photograph, assuming to be your contract, and it was something
And it was
else?
not, no. And then he asked me to pay him for the powder coating for the painting of the cabinet, which I did, $780. And we selected a color. And I asked for pictures of the cabinet after it was painted. And this went on for weeks and weeks and weeks. And I never received it from that initial bare aluminum rectangle structure that he sent me. I never received a photograph from him of any painted cabinet. And my cabinet was a step down cabinet, so it was L-shaped. I never received any photographs from him about that. And at that time, I began to question the validity of our relationship as far as supplier and vendor. And I started asking him, was it built? And then he says, yes, it is. And he was going to install it. And so the mason hadn't done the work yet. The mason did come out and pour a footer. And it was our understanding that as soon as that was done, the cabinet would go on. And it was well after Easter by this point. It was up in May.
Who was to pay the mason, or was that a part of the original contract?
It was a part of the original contract.
All right, go ahead.
And after the block was laid by the mason, it was led me to the cabinet was built and ready to install onto the structure that was provided by the mason. But that never happened. And
Have you ever seen the cabinet completed?
no, I asked again for more pictures. He said he was coming on several occasions to install the cabinet. And he never made it with the cabinet. Something happened each and every time. And there was this happened this time, and it was excuse after excuse after excuse, and this went on for a month, and I had already known.
Okay, that's
I'm sorry.
fine. You have anything else?
Nothing else.
Would you like to examine this witness?
Yeah, yes, Your Honor. So again, how long did you work with Mr. Stockton?
We started working 2022.
And before this incident, was your relationship with him pretty good?
It was. Mhm.
How many times do you think that you used his services?
Many, many countless times through the 22 and 23 and 24 up into this.
And never any issues until this incident?
With completion, I had no 100% issues. With full completion, I had the previous year in 2024, the summer and the fall, I had started receiving issues with the quality of materials he was using was inferior in the sign industry. And I started having problems with some of the signs he was installing were falling down or falling over. And I was having to either have him go back if I could get him to go back, or I was having to foot the bill to get that taken care of. So I did start to sense that something, you know.
But you still used his services?
Yeah, I did. I did.
And he sent you a picture of the cabinet he built for you, is that correct?
Yes, he did send me a picture of a metal a fabricated aluminum cabinet. Yes, sir.
And then a mason came and had to lay down a foundation for the cabinet, is that correct?
Correct.
And who paid for the mason services? I understand it was part of the contract, but was it Mr. Stockton that actually gave the money to the mason?
I have no knowledge of what he would have provided to the mason. I don't know how the mason, the agreement was that that he would pay the mason, but I don't know whether he paid the mason or not, sir.
But you didn't pay the mason, is that correct?
At that point, no, but I have paid him since then, yes.
You know, if Mr. Stockton mentioned to you any issues with the work the mason had done, anything that needed to be corrected?
Yes, he stated that the measurements were off on the block that he had laid and that he was going to have to adjust the cabinet to accommodate that.
And let me ask you, did you get any of your materials back or anything back from this contract from Mr. Stockton?
I didn't get any materials from him that that I hadn't paid for. I gave him the letters that I said were on that I had paid for it through Gemini. And I had the receipt for the payment of the letters, because in the sign industry, you have to build your cabinet and then you have to attach the letters to it once the cabinet is built. You can't attach the letters on site because it takes too much time. So you do that in the shop prior to going to the install. So I had given him the letters before that to install onto the cabinet.
And you were able to get all of those back, no issue, or?
I was able, those were all, I'd just like to note, those were all still in the boxes that they came in wrapped in the plastic that they were shipped in June, end of May, 1st of June, when the cabinet was supposed to have already been built and the letters supposed to be on it. We did get them back and they were in boxes wrapped in plastic.
That's all I need to have.
Will this witness be excused?
Yes, Your Honor.
Thank you.
Thank you.
One more question. Mr. Russell, did you ever receive anything from Mr. Stockton?
No, I did not. I did not.
She's under subpoena for the trial.
Not yet. No. But she
Well,
will.
let's have her recognized. What's the day of the trial?
That trial date is the 21st. I think that's correct.
You raise your right hand.
Which is it?
Both.
20th and 21st?
I have two, it depends on how many questions you ask. I'm gonna start out on.
Well, you won't let me ask many, Judge, so I'm all right.
To be short. You raise your right hand, you recognize under the penal sum of $500 to be present here on the 20th of this month.
The 20th?
20th.
Yes, sir.
Okay, thank you very much. Maybe excuse.
Thank you, Mr. Russell.
That concludes your test evidence on 404B.
That is it, John.
Would you like to make a short argument about it before? And then we'll see if council wants to.
Your Honor, from what you see in a very limited presentation here, that Mr. Stockton takes contracts and promises and gets paid in advance, and then he doesn't deliver. And then when the customers find out that something's amiss, he lies and lies and lies and continues to lie throughout. It shows a clear intent that he never intended.
And it's so similar to the accusation in this case, you say it shows a pattern of conduct.
Yes, sir.
Okay. Would you like to respond?
Yes, Your Honor. I just would say this is unduly prejudicial. I think you can see.
There's no doubt it's prejudicial.
Well, yeah, I'm just saying.
But they
it's-
wouldn't be using it if
Yeah.
it wasn't prejudicial.
Well, I'm just saying under the circumstance, Mr. Stockton, completed work for it. This, if anything, shows maybe a propensity for poor financial decisions. But I don't think it has a direct bearing on the case.
Well, I disagree with you. I'm gonna allow it in 404B evidence. I think it shows a pattern of conduct. It's not just similar, but exactly the same, especially since you took payments and made false statements according to the testimony. And I don't know that the jury will have to determine the factual aspects. So we will allow these witnesses. What's in an order to that effect? Okay, thank you all very much. We'll see you on trial day.
Thank you, Your Honor.
Jeremiah Shelton. How about that, you're Jeremiah Shelton, you are Jeremiah Shelton?
Yes, sir.
Okay, you were born in 2000?
Yes, sir.
The last four digits of your social security number 3175.
Yes, sir.
Okay, you're here for arraignment, you're represented by counsel, you have the right to remain silent. Grand jury, Clinton County's returning an indictment charging you with terroristic threatening, third degree, criminal mischief in the first degree, leaving the scene of an accident, wanton endangerment of first degree charges, 4 and 5. Do you understand what the charges are? Mr. Cross, you acknowledge the identity of your client for seeing indictment, waive formal reading and arraignment here, pleading not guilty, third and I'll plead no motion.
Yes, Your Honor.
We'll schedule a negotiation day on February the 2nd, and next court appearance for a pretrial is on February the 12th. Is there any objection to continue on the same line?
No, Your Honor.
Okay, okay, see you then. Kaylee Swift, Commonwealth versus Kaylee Swift. Twenty-five CR 007. Are you Kaylee Swift?
Yes.
You born in 2001? Born in 2001?
Yes.
Last four digits, social security number 2457.
Yes.
Okay, you're here for a hardship license. You're represented by Lee Whittenberg. He's not present. Is that correct?
Yes, that's correct.
Yeah. Mr. Stockton, have y'all reviewed the application for hardship license?
I have not reviewed it, but I know she's in a special report program to do it in Wales, so if she needs to go to work, attending report mandated requirements, I think she's entitled. Okay.
I'll enter the order, okay?
Okay.
Yeah, is there an order that's been submitted? Wittenberg is the one here. Right?
The application.
What kind of limited use of the driver's license do they ask for?
Either one the council, the work that's happening, being very medical, and they are conscious. And, still that day, they put Tuesday, eight, 9.
Can y'all get familiar with the clerk's office and pay the order?
Okay.
You need to see Mr. York, Mr. York, Mr. Mosey York. He's the guy over there that's wearing Tennessee orange t-shirt across the hall. Just let the bailiff take the file over there too, we'll go over there and okay. Thank you very much. Mitchell Thrasher. Commonwealth versus Mitchell Thrasher, 25 CR 0084. You Mitchell Thrasher,
Yes, sir.
born in 1964.
Yes, sir.
Last 4 days of social security. 5. What's the story?
Your Honor, we need probably about 60 days on this case. I need to wait for the Bethany Harding case is concluded before I consider this case.
Well, April 9th, you okay?
Be fine.
You go to it in March, or do you think April? Will be fair? Yeah, you shall next appear here on April the 9th, Commissioner your bond. Okay? Thank you. Leon Weaver. Commonwealth versus Leon Weaver, 25 CR 00107. Are you Leon Weaver?
Yes, sir, I am, Your Honor.
Good morning.
Good morning, sir.
Born in 1974.
Yes, sir.
Last 4 digits, social security number 3591.
Yes, sir.
We're here for a job conference. What's the Commonwealth have to say?
Your Honor, we've spoken with the victim in this case after I spoke to Mr. Kraus, and we just need one more negotiation day.
Negotiation day on February the 2nd. What time?
One p.m.
1 p.m. here, and the next court date's 9 a.m. on February 12th. Both of them are conditioned to be on. Okay. Thank you very much for attending.
Thank you, sir.
Yeah.
That's not.
Christopher Young.
We first get loose while ago because that was tied in with that Dusty Light thing.
But that was the one where we think there may be a conflict.
Yeah.
Yeah.
So his next court appearance.
Well, we need to set it for the next one, yeah.
Yeah, so he needs to be here on negotiation day on February 2nd, and the next court date is February
He was
12th with counsel. Okay. Is he here?
He was here.
Well, he shouldn't have been turned loose until we got him here and gave him that information, so.
Sorry, Ron, we called him.
Well, I'm just telling you, make sure he gets the information. I'm gonna have a hard time holding him in contempt when he wasn't here and heard that, is what I'm saying.
It's on the record, he standing right here.
And then nothing.
And that gets out of custody docket, except we had somebody we were coming back to. We had an interview that was done out in the hall with a potential victim. How did that go?
Your Honor, based on that interview, she satisfied the Commonwealth that there's ample resources around her if she needs aid and assistance, so I have no
And
objection.
that was the, which case was
That
it?
was. Yeah, Calnors.
It's okay. Change the cash in. Now, you had Kimberly Elmore, did you, previously?
Yes. Slots on that day to you. And slots. It's a shot.
Short.
That's what we did.
Okay, let's go on with the sentence. You've been previously identified with the cell board. You had an opportunity to do the pre-sentence investigation for
Yeah.
probation parole.
I do, yes.
Okay. So your reason why she shouldn't be sentenced. No, you are. On plea of guilty to trafficking in controlled substance, first, and she received 7 years probation, 5 years detention, for long-term inpatient treatment facility, determined by a schedule of probation parole. Then it shall be transported to the inpatient facility by probation parole. She should receive credit for time served. What's the court cost? $155. I'll let her pay that $30 a month, 30 days after she gets out of the long term. Now, what kind of arrangements have been made with her?
We cannot start that for our system until she's sentenced. We will start that tomorrow. It will probably be a week and a half to 2 weeks before we have been done.
I understand that. Mr. Stockton?
Yes.
Do you hear that?
Yes.
What's your position?
I guess we'll just have to wait till we get.
Well, I mean, I'm not convinced that she's not over medicated still, even if she does have a prescription. I'm very concerned. So I don't want to pick the newspaper up or, see online that I let you out of here today and you end up dead because you're taking too many drugs. Who you living with?
My mom.
Is your mom here? She is, right?
Yes. She stayed with me and she just takes what she's supposed to do. At bedtime, she takes what she's supposed to do.
Okay, well, Mom, I can't make you do anything, but I'm gonna trust you to be there with her, and I'm gonna put you under a curfew. You stay there with your mom.
Yeah, she stayed, she don't go anywhere.
You stay there with your mom and issue your bond, and I'll let you go, okay? When you come, be in contact with your attorney, and he'll tell you where the bed date is, and I'll tell you where they're gonna pick you up, okay? Okay, I'm just telling her that that's what she's supposed to do. Okay, thank you very much.
Thank you, Your Honor.
What was the court costing that?
$155.
I told her what to do about it. Okay. Okay, do we have anybody else on the docket that we haven't addressed?
Yes, Your Honor, April Collins.
How much was it? April Collins? Yeah. Was that key? Humboldt versus April Collins. 25 CR 0001114. We have previously identified you, and there was some talk about a plea. You go over that with her?
I have, Your Honor.
And where are we on that?
I believe you were reading her rights on it, but she agrees, she still wants the interim.
Was it a pretrial diversion?
Pretrial diversion.
Okay, I guess we were down, said a motion been tendered, currently on the influence, you said no, it's free and voluntary. Free and voluntary given, she equivocated on that. Is this plea freely and voluntary given?
Yes.
You're the same person that we identified in 25 CR 00114, correct?
Yes, Your Honor.
Judgment's not impaired today. We know that you discussed this with your attorney. Are you satisfied with his advice?
Yes. Yes.
Have you viewed the evidence Commonwealth has against you, believe you're fully informed about your case?
Yes.
You understand that you don't have to plead guilty. I'm going to go over certain rights you have under Kentucky and the United States Constitution. If you have any questions, step away from the podium and talk to the attorney. You have the right not to testify against yourself. No one can make you say anything about the speedy trial, but jury right to be represented by counsel to jury trial, the right to confront and cross and all witnesses called testify against you. The right to produce evidence, the right to call witnesses in favor, the right to produce no the higher court if you lose. The right to provide the Commonwealth prove on a reasonable doubt that you're guilty of charges against you. Understand that by entering a guilty plea, that you give up those rights. You understand that, ma'am?
Yes, Your Honor.
You may consider the Commonwealth's recommendation, but I may apply any major sense provide law. I don't have to accept the recommendation. And then I do not accept the recommendation, decide to impose a harsher sentence. You have the right to withdraw your plea and go to trial. Understand?
Sure.
And have you previously been diverted in the last 5 years? Okay, you have any felony convictions in the last 10 years?
I had one, I think, but they changed to the misdemeanor.
So it was not a felony conviction.
Sorry.
The answer would be yes, just nod your head. I'll forget that it's a voice act. Just hit on the podium, don't get over that. You heard the Commonwealth's recommendation? Mr. Huntley, are you giving the recommendation? Who's giving it?
It's, she'll plead guilty to operating a vehicle under the influence, receive a $200 fine, plead guilty to possession of controlled substance, 3 years pretrial, the verdict for 5. She'll enter a rehab facility of 180 days to be determined through DGA. She'll receive credit for time served, maintain employment or do community service. All evidence will be destroyed and pay court costs at discretion of the public.
Is that what you agree to, ma'am? Okay. Now you realize if you successfully complete the diversion program, those felony charges will be dismissed with the trial diversion. But if you do not successfully complete the diversion program, if you come back in front of them, you'll be convicted felon. It be used against you. On the DUI that you plead to, it is enhanced. So if you get another DUI, it can be enhanceable. You understand that?
Yes, Your Honor.
It'd be more serious. What are the total court costs?
$4,500, $820.
$120. You need some time to pay that.
Yes, Your
I'm
Honor.
gonna allow you to pay that at $40 a month, first payment. Starting, is that your signature on the document?
Yes, Your Honor.
So you're guilty because you are guilty for no other reason, is that right?
Yes.
Constitutional rights to you desire to go forward, allow me to fix your punishment, will arrange for you to the law. I'll accept the agreement, sign the diversion order, and I guess we'll have to have the DUI papers that they've been filled.
They
out.
are.
Okay, well, you need to meet with probation and parole, better. They'll give you some information, some guidelines, okay?
Okay.
Thank you very much. Now, does that conclude Michael Turner? Okay. This is 24 CR 002. This is Mr. Michael Taylor. We previously identified Mr. Taylor. He was born in 1984 and last 4 years of Social Security. What's the comment?
Mr. Poindexter furnished his expert report. My understanding, we're gonna stipulate competency and ask for mediation.
Yes,
Okay, is that true?
it is, Your Honor.
But we're reserving the issue. There's still gonna be, if there is a trial, he's give notice basically through his report of the notice of mental defect.
Right.
That way, there may be a criminal responsibility issue at trial.
So the issue is not competency, it's criminal responsibility.
Yes.
You
Yes, sir.
agree with that, you talked about that to your client.
I have, Your Honor.
Okay. So what do we need to do?
We just need to do a mediation order and get this case mediated.
Okay, we'll do a mediation and who are you using in mediation?
Been Judge Pat, he's very prompt about getting on set.
Yeah. Well, let's sign
Is
it.
that all right?
Sure.
Judge Patton. If Judge Patton is not available, you can talk to Justice Lambert. He does something he did too.
I don't think we can.
Okay. Okay. We'll be in contact.
Do you want to set it for another pretrial or just wait till after mediation?
Well, I don't know how long the mediation is gonna be, but we can, I guess, take a look at it on, if mediation is successful. We all need a negotiation day, Mr. Stockton, after mediation, so let's just set it for February the 12th. That's over a month out, see if the mediation is successful. If not, by agreed order, we can set it out again.
If we get the order here, Judge Pat, we quick about giving us some.
Thank you, Your Honor. Thank you very much. Does that conclude the criminal docket? I mean, the in-house here, we got some jails waiting here. Okay, let's go to Russell County first, since we just have a couple people there. Russell County, Attorney Cameron. Can somebody call Russell County, see if we get on? Let's go to Wayne County. Wayne County, Commonwealth versus Bryson Cross for sentencing. Commonwealth versus Bryson Cross, 25 CR 0098, 25 CR 0099. Are you Bryson Cross? Somebody needs to turn the microphone on.
Can you hear me?
Hear you now. Are you Bryson Cross?
Yes,
You were born in 2006.
yes,
Last 4 digits of your social security number are 2221, correct?
yes,
Here for sentencing, have you had an opportunity to look at the pre-sentence investigation report done by probation bureau?
yes,
Is it substantially correct?
yes,
Counselor, is there any reason this gentleman should not be sentenced?
No, Your Honor.
I want to plead guilty in indictment number 25 CR 0098 for charge of theft of lawful taking the defendant shall receive a sentence of 12 months. Under indictment number for the charge of The defendant shall receive 5 years and 12 months, and the 5 years shall run concurrently for a total of 5 years. That's on that 00098. On 0099, the charge of possession of a controlled substance, the defendant shall receive a sentence of 2.5 years. The 5 years under 98 and 2.5 years under 99 shall run consecutively for a total of 7.5 years, probated for 5 years, supervised, and shall enter into the long-term treatment facility for a minimum of 6 months, be scheduled by DPA to be followed by the Commonwealth. The defendant is currently incarcerated and shall remain so until final sentencing, which was today. The completion of 60 days in jail and the morning of the bed day. He's got 60 days in.
I believe he does have the 60 days.
So when do y'all have him in bed day?
So I have him in bed at Spark, but unfortunately they are quarantined right now due to COVID. So the earliest that he could go there would be the 19th. He's advised me that he would like for me to find a different placement for him.
Okay, we'll find a different place and clear it with the Commonwealth and agree order. The defendant shall pay restitution of $197.21 to the clerk's office, 5% fee, and what are the courthouse.
Won't be basketball,
So $155.97.21.
$350
You can pay that at $30 a month on getting out of the rehab. Okay? So your attorney will get a hold of you as soon as they are able to find you a placement. Okay, thank you very much.
Thank you.
Isaac Dalton.
Yes, sir.
Good morning. Commonwealth versus Isaac Dalton, 25 00105. Are you Isaac Dalton?
Yes, sir.
With 1988?
Yes, sir.
With this social security number are 3833.
Yes, sir.
Sentencing, you get an opportunity to look at the pre-sentence investigation report, number probation and parole. Have you, is it substantially correct?
Yes, sir.
Any reason why this gentleman should not be sentenced today?
No, Your Honor.
Upon a plea of guilty to strangulation, first degree, he should receive a sentence of 5 years. The sentence is run consecutively to Cumberland Circuit Court Case 21 CR 0034. Okay? Okay, and I guess probation and parole will need some information you got in the other case.
He's already staying back.
Okay, he's already stated that. Okay, thank you very much.
Thank you.
David Hosschop.
Good morning, Your Honor.
Okay, you need to raise the camera a little bit there. Somebody, or you need to sit down one or the other. I can't see your head. You've been decapitated. Okay, that's good.
Good morning, Your Honor.
Your affidavit here, and I'm gonna approve. But why is it that you have no income? Are you disabled?
Currently, I don't have a job.
When was the last job that you had?
Well, I came down from New Jersey to start working as a contractor for a friend of mine, and it didn't work out. And so I was on my way back to New Jersey when I came through Kentucky and went around the corner and went too close to the policeman and got arrested.
Yeah, okay. So it's been a while, so I'm gonna go ahead and sign the order allowing you to have a public advocate. Public advocates here, hit the microphone. Public advocate.
Hello, David.
Hello.
He'll be over to see you soon. This is just for the purpose of arraignment right now. You have the right to remain silent. The grand jury of Clinton County has returned an indictment charging you with operating a motor vehicle under the influence, license not being in possession of marijuana, reckless driving, unobstructed windshield, failure to maintain insurance, wanton endangerment in first degree. You understand what those charges are. I don't want what you did, but you understand what the charges are.
I understand the charges, but I don't believe them.
Okay, wait, that's the only thing I asked you because you might incriminate yourself. Counselor, do you acknowledge the identity of your client received indictment, waive formal reading and arraignment, enter plea not guilty, reserving all plea trial motions?
Yes, Your Honor.
Okay, I'm gonna set a negotiation day on February the second, and the next court date on February the 12th. Your attorney will be over to discuss your situation, which would include the possibility of a bond modification or that sort of stuff, but I think you need an opportunity to talk to him privately. And when will you be over to see him?
I can come see him today.
He'll be over to see you this afternoon sometime, okay? And then you can talk to him in a private area where you get counsel. Okay, thank you very much.
Thank you, Your Honor. Have a good day.
Dawson Jarvis.
Yes.
Good morning, Mr. Jarvis.
Good morning.
This is 25 CR 009 and 25 CR 016. 2001 and the last four digits of your social security number are 7215. These are motion for shock probation. What do you have to say, Mr. Pointer?
Your Honor, we had filed this motion and you had heard it on December court date, but Mr. Stockton was not here. And he had previously said that he would be in agreement after the first of the year. So I said I would consider it. Consider it at the first of the year. Sorry. And I guess my question is if Mr. Jarvis is ready to take his recovery seriously. He didn't when he was in the specialty court. He was always testing positive for Suboxone and even had it in his pocket. So if he's willing to start and take this seriously and know there's consequences, I'll go along.
What kind of plans does Mr. Jarvis have?
We've got a,
You want treatment, Mr. Stockton, of some
yes, I
sort?
do. Well, if he didn't take advantage of the first opportunity.
What do you want?
Long-term treatment. And Your Honor, we submitted a bed letter from Spark Recovery Center. We've got an updated one from January 6th. And I believe they're even watching on YouTube to see what happens today. So they're ready to take him as soon.
Where are they located?
This one is in Russell Springs, Kentucky. Your Honor.
Under lockdown too. That's the one he just said's under lockdown.
Yeah, that's my understanding. Yeah. But yeah.
But they're under lockdown.
Can't go.
That's what I was told yesterday.
They're under lockdown till, what'd you say, the
The
19th?
19th.
Okay. Okay.
Go upstairs. Yeah, he might want to get his immunity for COVID up, just go ahead and get out of the way and go over there.
That's all right.
Yeah, okay, well, as soon as, I'll agree with that. We'll shock him and put him in Spark. If you have a delay in Spark or need to go somewhere else, you need to call Mr. Stockton and get approval of the supplement.
Yes, sir.
Now, they have is this treatment center that they've opened up here in Clinton County, is it a lockdown facility? It's not.
Foothills Academy.
Well, it's Foothills Treatment Center now.
Yeah, that's the place. So I'm about the same place.
Foothills Recovery, yeah. Okay, well, as soon as they got the COVID over there, Mr. Jarvis, so as soon as they get that up, they'll move you, okay?
Okay, thank you very much.
Who's the transport? Will Spark come over and get him?
They will, Your Honor.
Okay, have Spark come over, give a Spark if you're on there, keep in contact with Mr. Poindexter.
All right, thank you
very much. Jeremy Kempton.
I'll take it.
Commonwealth versus Jeremy Kempton. 23 CR 0030. Mr. Kempton, you're cut off too. Might need to, somebody needs to raise that camera a little bit. Or sit down, yeah. That's good. We're here on 23 CR 0030 for probation revocation. You are Jeremy Kempton.
Yes, sir.
Born in 1981, last 4 digits, social security number 2874.
Yes.
Okay, what do you have?
I've been informed Mr. Kempton wants a hearing. Mr. Kempton was charged with assault second degree on December the 3rd in Wayne County when he allegedly stabbed his live-in Angela Guerrera with a knife. He was supposed to have been intoxicated, acting aggressive, and he shouldn't even been there living with her to start with because she's a convicted felon. Is that right, Mr. Payne?
According to Dr. tomorrow.
Yeah, so if he wants a hearing, I'll have to subpoena the officers from Wayne County along with Ms. Guerra.
Have him come back here on February the 12th for a hearing. Now, can we put a pin in on him since will he be one of yours or the county will have to pay for him? I think he's eligible for a pin and we're holding for a probation revocation. Jeremy Kempton, 23 CR 0030.
It would be all right if the officers are here, but then
You get no objection from us.
Okay, your attorney will be in contact with you.
Thank you.
An order will be here, we need it. No, Megan has to do that, she knows.
Stephanie Prater. Commonwealth versus Stephanie Prater, 24 CR 0092. Are you Stephanie Prater?
Yes, sir.
Good morning. Were you born in 1999?
Yes, sir.
4 digits social security number 2280.
Yes, sir.
Sentencing, have you had an opportunity to look at pre-sentence investigation report done by probation and parole?
Yes, sir.
Substantially correct.
Yes, sir.
Okay, is there any reason that this police should not be sentenced?
No, Your Honor.
The slave was previously given 2 years pretrial verdict for 4 on December the 4th, 2025. The previously granted pretrial version was voided. Therefore, we sentence her to 2 years. What's the court cost involved in this? $155. You'll start paying at $30 a month, 30 days after you're released, okay? Thank you very much. Very much. Did we ever get Russell County on the line? Russell County, will you turn your camera on, please? Thank you very much. Winter Brown for sentencing. Commonwealth versus Winter Brown. 23 CR 0065. Are you Winter Brown?
Yes,
You born in 1961?
yes, sir.
Last 4 digits social security number are 0964.
Yes, sir.
Y'all are key in the mic if the prosecution takes it over. Is there any reason why this lady should not be sentenced?
No, Your Honor.
Upon a plea of guilty, possession of controlled substance, first methamphetamine, first offense, 2 counts of finish, to receive a sentence. 3 years on each count to run concurrently, total of 3 years, probated for 5 years, she has received credit for time served. All evidence to be destroyed. What's the court file?
155.
155. Now, when can probation need her?
I will call over there and give her the instructions and send them paperwork for her to sign as soon as you get out.
Okay, they're gonna send the paperwork, you get out today, probation and parole is gonna send you the stuff, you have to pay $155, you need some time to pay that.
Just, I should be able to get it by tomorrow.
Well, I'm gonna give you more time than that, you pay $30 in 30 days, and $30 every day, you pay the 155, but if you wanna pay it all, you can, okay?
Okay,
Okay, he'll be over to meet with you this afternoon, okay?
okay, thank you.
So much. Bethany Harding. For arraignment. Are you Bethany Harding?
Yes.
Okay, good morning. Well, it's not over there. I guess it's good afternoon over there. Were you born in 1992?
Yes, sir.
Last 4 digits, social security number 0901.
Yes.
You're here on 25 CR 0086 for pretrial and for arraignment on 25 CR 00121. Now, the first thing, the number on here doesn't match. We also have another indictment, 2025 If,
I had to.
oh yeah, I see it. It's all on 21. So you've been, the grand jury has charged you with speeding, fleeing and evading first degree, fleeing and evading police in second degree on foot. Operating motor vehicle under the influence, operating motor vehicle while revoked. Failure to surrender revoked driver's license, failure to signal, and possession of open alcohol container. You understand those charges?
Yes, sir.
Mr. Cross, you're representing this lady,
Your Honor, here's where we are on this.
Wait, let's get some attention here, okay? Mr. Cross.
I represent her.
Wait just a second. Do you acknowledge her identity?
Yes, but I wanted to explain, I wanted to limit my appearance because as I was going to explain.
Well, let me get her in front of you.
Okay.
Okay. So you acknowledge her identity and receive the indictment, but you want a limited appearance for you.
For me, yes, correct. And quick word of explanation, I represent her in the first case. It's a lot easier if the same attorney's doing this, but I've got to go meet with Ms. Harden and determine what future course we'll take, and I'll let Mr. Stockton know before February 2nd.
In other words, the wheel needs to be greased.
We're gonna have a better understanding.
Yeah, I
Yes.
understand. Okay, well, I'm gonna sign the standard discovery order. When will you know whether you will reach a court?
Sometime before the 2nd of, I'll let Mr. Stockton know, probably for the next 2 weeks.
Well, I'd really like for you to do it a week before the 2nd so she can have somebody else.
That's fine. Well, it'll be the public defender if it's not me, I'm sure, but I'll get with Mr. Stockton and we'll let you know.
Okay.
I'll file a notice.
And you'll be there on the other case for negotiation
Right.
anyway.
I'm gonna try to help
Next
her.
court appearance is February the 12th. Okay?
Thank you.
Is that all we have in Russell County? If so, y'all can be excused, and thank you for your cooperation. It's always excellent, Russell County. Thank you very much.
Thank you, Your Honor. Y'all have a good day.
You too. Clinton County Jail. Clinton County Jail. Clinton County Jail, are you there? Okay, you kind of have, Justin Davis.
Hold on, Your Honor, 1 moment. Justin Davis? Yeah. Get him a grant.
Justin Davis, Robert Hurt, Chad Jones, and William Willis.
Hold on 1 moment, Your Honor.
Necessarily in that order.
He's not here, Your Honor.
Okay, you are Justin Daly?
Yes, Your Honor.
Good morning. You're
Good
here on 24 CR 0079 for sentencing. What's your year of birth, sir?
10/13/1989,
Last 4 digits of social security number.
6037.
Okay, we're here today for sentencing. Have you had an opportunity to look at the pre-sentence investigation done by probation and parole?
Yeah.
Yeah. Is it, Counselor, is it substantially correct?
It is, Your Honor.
Is there any reason this gentleman should not be sentenced?
No, Your Honor.
Upon pleading guilty to unlawful transaction with a minor, 2 degrees, 2 counts, then shall receive a sentence of 5 years with each count to run consecutively 2 years. Then agrees to have any and all other evidence disposed of. What are the court costs? $155. Considering the length of the sentence, I'm going to waive the court costs. There's no reason to charge it.
Thank you.
Court costs. So the judge will be in it. Thank you very much, sir.
Thank you, Your Honor.
Robert Hurt. Commonwealth versus Robert Hurt. 25 CR 00116. Are you Robert Hurt?
Yes, sir.
Good morning.
Morning.
Were you born in 1978, sir?
Yes, sir.
Last 4 digits, social security number 5604.
Yes, sir.
Got a pretrial conference. What's the common purpose?
In this case, if you want another negotiation.
Yes, sir. Get a negotiation day for February the 2nd, and the next court date's February the 12th. What's Mr. Hurt charged with again?
He's charged with theft and receiving stolen property. He allegedly had a bunch of copper that comes from the media filing, cable line, telephone lines, and put it on his truck.
What's his bond?
It's 25.
Cash.
Yeah, he's got a extensive payment.
Okay.
If we could-
You can talk to Commonwealth about that,
Okay.
and, see, if you want to make a recommendation on his bond situation, I'll consider it.
Okay.
If you can't reach an agreement, we'll have to have a bond hearing sometime before then, or he'll be here the 2nd. What?
Okay, I'm just gonna let the court know that his mother was here and she has property, but not that much property to do a 50,000 property bond. She could do a 10,000 property bond that way. And home incarceration.
Well, you just go ahead and talk to Mr. Stockton about it. Okay. And Mr. Stockton can have someone in the Commonwealth Attorney's Office interview the mother with you to see what she.
Oh, I know his mother, she's a fine person. We're related. And, good, and I know she'd be good for it. I just need to talk to the sheriff. One extra, want to send me a Rio or the property bond that she's making, home incarceration, I'll talk to anybody. Yes, sir. Okay, thank you. Thank you.
Thank you very much.
Judge, that's all I have. Thank you.
Absolutely.
Thanks, sir.
Commonwealth versus Chad Jones. Commonwealth versus Chad Jones, 25 CR 00104. Here for sentencing. Are you Chad Jones?
Yes, sir.
Good afternoon.
Good afternoon.
Is your year of birth 1984?
Yes, sir.
Last 4 digits social security number 1898.
Yes, sir.
You're here for sentencing. Have you seen the pre-sentence investigation report done by probation and parole?
I'm sorry.
You've seen this pre-sentence investigation report done by probation and parole?
Oh, yes, sir.
Okay, counselor, is it substantially correct?
It is, Your Honor.
Is there any reason this gentleman should not be sentenced?
No, Your Honor.
On pleading guilty to criminal mischief first degree, he shall receive a sentence of 5 years probation. In 5 years, he shall enter a complete long-term treatment program. The defendant shall be transported to the facility by probation and parole. The bed date shall be scheduled after final hearing. The defendant shall pay restitution of $613.50 to Circuit Clerk's office, $50 a month, subject to 5%. Clerk's fee is start 30 days after his release from the long-term treatment. She'll receive credit for time served. What the court cost is. $768, but that includes restitution. Okay, well, let's continue the payments at $50 a month for the whole amount. Okay? And,
Hey, Judge. On him, in the treatment center that DPA finds, usually they come and pick them up. Is it okay if the treatment center picks him up?
it's okay with you, it's okay with me, but what you need to do is communicate to corrections or someone.
Yes.
They have paper sufficient to turn them over. Doesn't bother me if y'all have, maybe, will the jail let them
When he
out?
gets the bed date, I will get with Megan, or I can send something to jail and release him when we get ready.
That's fine. We have a few jails that don't want to let people out without pay, not all.
Just like-
Okay, William Willis.
Hey, William.
Commonwealth versus William Willis, 24 CR 0014, 24 CR 0015. Are you William Willis?
Yes, sir.
Peggy. Good morning. I was just making sure. You're here on these two pretrial diversion revocations. Were you born in 1997?
Yes, sir.
4 digit social security 1336.
Yes, sir.
Okay. What's the Commonwealth have to say?
Your Honor, this is a motion to revoke that we filed. He also, part of the basis of that is he's got a new case going before the grand jury today. And Mr. Carlton and I've discussed if we'd like to enter an order having the assessed for specialty authority, say February the second negotiation next February.
That's correct, Your Honor, and for Mr. Willis's benefit, since we didn't get this done till this morning. You're being indicted today, we believe, William, but you're gonna be assessed for drug court, and I'll be down to see you first of the week, okay?
Okay, so I'll be getting out this February in drug court?
Wait just a second. Your attorney will talk to you.
I'll be
about it.
down to
Y'all
see
aren't gonna be having any more discussions. You'll be having a private conversation.
I'll be down to see you, sir,
You'll
okay?
be down today, okay?
Thank you.
Okay, does that complete the criminal docket? Mr. Stockton, is there anything on Zoom or local that we passed over?
I think we've covered everything.
Praise the Lord.
Yeah, I
Got
agree.
everybody in.
I think that's sufficient, what we've done this morning.
Subject to my gross limitations on inquiry by counsel. Mr. Hanlon, we finished by noon because of my gross limitation on inquiry by counsel.
Yeah, we. Yeah,
Call the 1 o'clock child support docket. Did the county attorney survive? Oh, yeah, there you are. That's right. I thought the game last night was very hard.
It's not one that I've been talking about, so it's.
Okay, Shelton versus Shelton.
Haven't agreed or not. It's been submitted electronically.
Sloan versus Sloan.
Agreed orders submitted.
Dodge versus Cornwell.
Here, I think.
Okay, what do we have here?
Judge, and this one, Ms. Cornwell's order, there's two kids, this is arrears only. 578 a month, I think this was transferred up from Florida. Last payment was on 7/18 of 25 in the amount of $400. Their arrearages, it's 22,944. And asking to pay 800 by February the 11th of 26.
Who's short, who's biological? What, tell me the story here.
She's the mother.
I'm the mother of them.
And who is Mary Dodge?
That is my husband's, and she is, when we lived in Florida, ended up with our two children because we had a DCF case down there.
Yeah, okay, I understand. Have you checked out what kind of income this lady has or staff?
None that I'm aware of.
I have no
Wait
income.
just a second, I'll call him.
Yeah, Steph's not, then I can put her under oath with me, or you can put her under oath and we can ask the questions, so.
For a testimony about to give us the truth.
I do.
State your name.
Okay, Stephanie Witham.
Okay, Ms. Witham, are you aware of, any income or what income Ms. Cornwell has?
I'm not aware of any income from Ms. Cornwell.
Okay, was this case transferred from Florida?
Yes,
Okay, is it arrears only?
yes.
And, what's the arrearage amount?
22,944.14.
Okay, and when was the last payment?
July the 18th of 25, an amount of $400.
Okay, and what was you asking that, be paid?
We're asking for $800 by February the 11th.
Yeah, that's kind of where we're at now.
Do what?
That's,
Well, okay, so if she doesn't pay the 811, do you want me to jail her?
yeah, 60 days.
So she might as well go get her toothbrush now.
Yeah.
Okay, you wanna raise your right hand? Swear the testimony about to give us the truth, no truth, nothing but the truth.
I do.
Okay, you wanna inquire as far as your income, I think.
State your name.
Crystal Cornwell,
Ms. Cornwell, what's your address?
1718 Sugar Valley Road here in Albany.
Okay, and, how long have you resided here?
13 years.
Okay. I know your last payment was July 18th at $400. At this time, do you have any type of income?
I have no income for myself. I do get KTAP for the 3 children that I'm currently raising and have custody of. And that's in the amount of $341 a month. My husband's the only one that works.
How old's the children?
4, 2, and 1.
Oh, little ones.
Yes.
And I see you're on a walk. Are you on some type of disability or have?
I'm actually fighting for disability. We just had to file another appeal. We're waiting on that. And then I had surgery November 19th on my left foot for ligament problems.
You don't have to get in real depth, but I used to do some social security. Have you filed the reconsideration? Is that where you're at?
I
right
have
now?
an attorney that's helping me with it.
Okay. So, yeah, so.
My husband did tell me this morning that if I can at least get 2 weeks, he can put something on it next week, not next week, but the following week. He also said that when he gets his taxes in, because we don't file together because of it, that we would take a good portion of that to put on it as well. And honestly, I thought that I'd been paying it, but with everything going on, the 3 kids, and I've had so much, I would.
Who are these 3 children? Who are these 3 children you have?
They're my nieces and nephews.
So you're raising nieces and nephews?
Yes, and I have a 14-year-old that is biologically mine.
So kind of stuck between a rock and a hard place, so what do you think you could come up with, given X amount of time?
How
In
much,
2 weeks,
how much she supposed to be a month?
578.
I mean. That takes the arrearage down to what, on a 3 years, or how long is 578 take?
500
4
a year would
years.
be 6,000 at 500 a year, so yeah, you're looking at 4 or 5 years.
4 or 5 years.
Yeah.
She can't pay
No,
$100.
I agree. So,
Do we have the ability to lower the payment?
we do, since they've transferred it to us, would you?
I never have done one. I mean, when you start amending another state's order, you get into the reciprocal act or something like that. What I'm gonna do is she'll make a full payment, one full payment. And then try to keep that back. I'm not gonna come up with 800 something. I'll give you 30 days to do a full payment. Actually, I'll give you to February the 12th. You have a full payment made, and then you pick the payments up after that. And if you can't make those, you'll need to go to public aid or somebody down in Florida to get them to amend that order.
yes, sir.
Somebody down there, because
That's that stuff, that order.
yeah, we can't ignore that order. But I also don't want to enter a judgment that I know can't be carried out. That kind of diminishes the respect of the court system. But the other thing is it wouldn't be bad to try to negotiate a lump sum for those people down there.
Right.
If you would like pay them $12,000 or something like that, pay it all at once. Sometimes people do that. I've experienced. Are you y'all are keying the mic. Y'all are keying the mic, please. Mr. Cross, you're keying the mic. Thank you. So in any event, do y'all ever contact other states about that, or is it within?
Usually advise them to contact them directly. Okay. An
Yeah.
agreement like that.
I've been trying to get rid of them and I can't.
Well, what about your relative down there that has the judgment? Y'all talk to each other at all?
We haven't spoken in 13 years since the last time I saw my 2 eldest children. Which are now 18 and fixing to be 19.
Okay, well, you just try to make some contacts down there while you got a breathing space here. Okay. And maybe you need, I guess it's public agencies representing the relatives who probably didn't have their attorney. Okay, thank you very much. What's the date? She got the 11th?
12th, I think you said the
Well, the
12th.
12th is the rule day.
Okay.
So she needs to make the payment by the 11th and, or be here, and we'll have to do something.
Thank
Okay,
you.
thank you. Hubbard versus Hal. Motion to include child support. Stevie Hal and Larissa Hubbard. Okay, what do we have here?
This is a motion to increase, Judge.
Yes, you're Larissa
Yes.
Hubbard. So then you probably will have a grant. And you are Stephen Hal.
Yes, sir.
Okay, tell us about the motion.
Go ahead and have staff testify. We'll put on the roll.
For testimony about to give us truth, whole truth, that's true.
I do.
State your name.
Stephanie Smith,
By whom are you employed?
Clinton County Child Support
What's your position?
caseworker.
Are you familiar with the case we're hearing today involving Stephen Howe?
Yes,
Okay, and was a motion to increase child support been filed in this case?
yes.
Okay, and what was the basis for that motion?
Increase in pay.
Okay, do you get the income from both parents?
Yes,
Okay, and Was that ran through the Kentucky Child Support Guideline?
Yes,
Okay, and how many children are there in this case?
2 children,
Okay, and what is the current child support?
$433 per month.
Okay, when was that set?
September 1st, 2022.
Okay, and what are you asking that the child support be increased to now?
The guidelines state $618 per month,
Okay, effective, when?
January 1st.
Okay, and what wages were used to come up with this amount?
Each of the parties' wages.
Okay. And did each party voluntarily give you their wages to,
Yes, I think we got his from his employer.
okay, okay. And where does he work? If you recall, you may not recall.
I don't recall.
Don't recall. Okay. Hardwoods.
Yeah.
Okay. Okay. Judge, that's the basis for the motion there was the increase in income.
Would you like to ask any questions?
In 14 weeks of the pay cycle since I started my job, I've only received 4 paychecks of 40 hours or better. I have all the math in my last pay stub for the end of the year. And if you extrapolate it out through a 52-week pay cycle, it's $11,600 less than what it would be at 40 hours. I have all of it.
Well, let me put him under, raise your right hand, you swear the testimony about to give us the truth, whole truth.
Yes, sir.
Okay.
State your name.
Stephen Howe,
Okay, Mr. Howe, where are you employed?
Eagle Hardwoods.
Okay, where's that?
Previously known as Somerset Hardwoods.
Okay,
It's on Racetrack Road, Somerset,
okay. And how long have you worked there?
since September 22nd.
2025.
Yes,
And what is your hourly rate?
1851.
Okay. And how many checks had you said you
There's
received?
14 pay cycles.
14 pay cycles.
Yes, sir.
Okay. And what has been your average weekly income?
$517 gross.
So what's been your net on average?
About 350.
So how many hours have you been averaging a week?
Roughly about 30, 32.
How much,
Sure.
how much,
1851 an hour. I have all my pay stubs right here in my brain home, 350. And that's all 14 of them, the next 3 pages. My first 3 weeks were the only consecutive weeks of 40 hours. And since then, there was 2 fires, vacuum system goes down. Anytime a film doesn't get turned, we don't go to work. I had previously, before that, I had to get this job, I had left Tyson to go back to the railroad because I received my offer letter. And then they pulled their offer letter, which put me out of a much better paying job. Of course, it's travel work, so I've been away from home a lot, but I had previously worked on the railroad and affording my child support some problem to get plenty of overtime. But then put me in a bind, I had to find a job fast. Here I am. It's a decent wage. Not many places pay $18 or better an hour. But I'm not getting 40 hours.
yeah.
I noticed in November and, you know, it's 27, 27, the December is 29, 30, 36, and 30. Have they indicated when you may be getting 40 hours?
They have not. But for the first week of November, they cut us back to 9-hour shifts, 4 days a week. But we only work 3 days a week, because we're all at 27, and then the whole week of Thanksgiving, we were off, no pay. We were just off 2 weeks for Christmas. And luckily, I had already earned a week vacation, my 60 days. I used my
2 weeks
vacation.
on Christmas and didn't pay anything?
No, we had the 3 days of holiday pay, and I used my entire week of vacation to supplement the rest. And outside of overtime and bonuses, it's $7,241. Is what I made in 14 weeks.
You applied for any other jobs?
Yes, I've been applying.
Where all have you applied to?
Indeed, a bunch of commercial electrician jobs. I applied at the Dollar General, the Advance, the O'Reilly's in town. Just something to supplement until either orders pick back up, because it's under new management. Eagle Hardwoods bought out Somerset Hardwoods about a year ago, so in the works of trying to get, better revenue and more orders and stuff, but.
Blame it on Trump, everybody else.
So it's hard with flooring, it's a tough market. A lot of hands in the pot.
Nothing else from this gentleman.
Yeah. Well, I'm gonna hold this in abeyance. I think he's given sufficient testimony in the things record to call it a question situation. I'd like for your people to take those numbers, calculate on those numbers that we have there will be some increase. And then we'll take a look at it in a few months.
Sorry, can we set something to adjust visitation? We have a 9-year-old agreement.
This is not about visitation.
Okay.
Only thing in front of me is jobs.
Okay.
But, if you got some disagreement about visitation, it's better to try to work with each other and talk it all. Than it is for both of you to hire lawyers up, because it'll sure eat up your child support, it'll eat up the money you can pay on child support. So I don't know if they all are civil enough to eat for each other and talk about it. But it's time to let that stuff go. It's hard to let things go. It's happened in the past. No, you don't need to say anything about it. So are you willing to talk to him about it? Or why don't y'all get in a public place out here in the hall and see if you can find your hearts to try to work out what's in the best interest of the child, okay? Okay, thank y'all very much. We'll be getting back, they'll get back with an order, they'll submit an order based upon these calculations. I will not reduce your child support based on these, but if there's a raise indicated, then we'll review it again in 6 months, okay?
Okay, thank you.
Thank y'all very much. Cabinet versus Cooper. What we got here?
Just as a contempt, Mr. Henry, I didn't know he was in this, so. Okay, on this one, the order to pay $450 a month on current, 90 on arrears. It's one child at the age of 8. The current arrearage is $1,344.33. The last payment was on September 19th, 2025, in the amount of $750. We were asking that $700 be paid by February the 11th. So basically one payment plus $250.
We can pay $700 by February 11th.
Okay.
We'd hope to do it by today, if he hasn't, we can by September, or February 11th.
February 11th, which is the day before rule day, so we'll schedule this on the 12th, and if payment is made, it won't be necessary to be here, okay? Thank y'all. Cabinet versus Wyman. Cabinet versus.
You're going to come and sign an agreed order at the office, Judge.
Okay, electronic file. Shelton versus Storch.
Agreed order signed, Judge.
Cabinet versus Davis.
Yes, this is a motion for decrease. One of the children's been emancipated. There's one child left and, so I guess we can have Steph testify real quickly.
Raise your right hand, you swear the testimony about to get the truth on it.
State your name.
Stephanie Wickham,
By whom are you employed?
Clinton County Child Support.
And are you familiar with the case we have, Hosapple versus Dallas?
Yes.
Okay, was this motion?
She goes just a little bit, please.
Motion to decrease?
Yes.
And what was this based on?
One of the children emancipated,
Okay,
the oldest,
so what was the previous amount?
I don't know. 317.
Okay, and based upon the new calculation, after the emancipation was figured in, what's the amount that you're asking for?
216 per month.
Okay, and is that based upon the Kentucky Child Support Guidelines?
Yes.
Okay, Smith's order. Fuller versus Rader.
Agreed order submitted electronically, Judge.
Burling versus Cavalier.
I'm going to continue that, Judge.
Okay. Smith versus Dean.
Agreed order submitted electronically, Judge.
Okay.
That's all for today.
Thank you very much.
Thank you, Judge.
civil docket will start in 5 minutes. Let's go off the record.
I'm sorry, which case was called? You're muted, Your Honor.
Some people prefer that. Shelton versus Storch.
I represent Ms. Storch, Your Honor, Cassandra Combs.
Go ahead.
This is our motion to modify the current time sharing arrangement. There is that pending criminal matter, and I got to hear a little bit of it earlier on your criminal docket. And I've also been made aware that there was a DCBS investigation that was unsubstantiated. And we believe that there are some issues here, and with the criminal matter not being resolved today, we think that he does need to be supervised with this child. If there are issues such as him assaulting someone, is he going to act that way in front of the child? And what way is he acting with this child that we are not privy to? The unsubstantiation, I'm not concerned about the unsubstantiation portion of this, Your Honor, because DCBS is not be all end all. There's issues that they don't get involved with that don't meet the criteria. That doesn't mean that there's not a problem. And I think that there is some sort of problem here. And we would just ask that the court take allegations seriously.
Wait a second, Mr. Cross, what do you have to say?
Your Honor, I don't think there's any problem regarding the child. We do have a copy of the DCBS letter.
That doesn't hold much weight to me. I mean, they do central intake.
I understand that, but it does say unsubstantiated.
Well, everybody's unsubstantiated. They hadn't substantiated one in Cumberland County in 10 years, I don't think. So, I mean, it doesn't mean it is substantiated. It's worth that.
Your Honor,
where did this alleged assault take place?
there was an assault in the Cartwright community purportedly involving Mr. Shelton and his father. And his father's here and can offer some testimony. I haven't spoken to him, but it's my understanding he'd like to come forward and testify.
Well, we're not gonna take a lot of testimony.
Don't need a lot, but
We're not gonna take any, okay?
the child is not
Wait
present.
just a second.
Sorry.
Now, this is the sort of thing, if you feel strongly about it, that can't be handled on a regular rule day. We'll need to set a motion if you want a motion on it. So if you got your calendar there, and is there one child involved?
Yes, Your Honor.
How old is the child?
7 years.
Okay,
He's actually 6, Your Honor.
Oops, my bad. What it was supposed to be, what, yeah. I don't remember.
We have court in the 22nd, Mr. Cross.
Thank you. We can get that continued, I hope, pending this.
what do you have on 22nd?
Oh, she's filed a motion in Woodford Family Court on this.
It's an EPO, Your Honor. They've been, and I don't represent her on that matter, but they have, Judge Fuchs in Woodford County has been putting off that hearing pending the issues here.
So the child's in Woodford County?
Lexington or Versailles one, yes. Mhm.
The child's been primarily living there, and then time sharing has been occurring with the father there in Clinton County, Your Honor.
Correct.
What's the EPO about?
We don't understand it. I'll let Ms. Combs, of course, she doesn't
She
represent it.
doesn't represent her on there, but it's factually related. It's as related to this case as the criminal case is.
It's based on this criminal case solely, is my understanding, and the child is nowhere present.
I don't want to litigate the EPO matter because it's not in Clinton County and I don't represent her, but that criminal matter.
Allegation is about, is the allegation related to the criminal matter down here? Is that what the allegation is?
Yes, that is my understanding, that she had concerns about the criminal matters and she went and filed an EPO.
I don't see how you get an EPO if you're concerned about a criminal matter if it doesn't directly affect the applicant.
We started the hearing up there, Your Honor, and then the family court judge decided just to defer to down here and see what came up here, so.
Yeah, let me see.
I don't think the proof.
Wait a second.
Sorry.
I should have the allegation and petition. Well, here's what I think without hearing. There's something going on with you when you've got different groups of people making allegations like this, that you're yelling and screaming that the mother of your child and you get in this altercation with your father. There's some kind of anger issue or something going on. I need to have a hearing on it. What kind of visitation is going on now?
You're not seeing the child at all now, so.
Why is he not seeing the child at all? What kind of agreements in place?
But Your Honor, they filed this EPO in Woodford County, and with the pending criminal case, I told them we needed this to.
Well, there's not an order in
No,
place. This
it's
is,
full-time,
this is self-directed, backing away from it. I think that's a good idea and I think that's good advice. So let's look, if we need to have a hearing, should we wait till the criminal case is resolved before we do it?
I think we need to go ahead and have it as soon as possible, Your Honor. I'd like to have it before the 22nd. And what I was going to offer a while ago, should
You think the case will be resolved on February the 12th? What's on the 22nd?
I think that's the EPO matter.
Okay, well, what about, do you think the criminal matter will be resolved here on February the 12th? You got it. I know.
It's like.
But you got a negotiation on February the 2nd, right?
Yes.
I mean, is this something that's gonna be resolved?
I've been led to believe that there's a strong likelihood that it would be.
Okay, well, let's just set this again on February the 12th. That could get us beyond the criminal matter, and if it doesn't get us beyond the criminal matter, if it doesn't get us beyond the criminal matter, we'll have a hearing on the 12th.
Okay. That's fine.
And in council, here's the thing about it. Wait just a second here. Wait just a second. I'm gonna ask Mr. Cross to inform you if the criminal matter has been resolved and what the resolution of that, and maybe if it has been resolved in some way, there can be negotiation. And do you want, is there a no contact order or anything there, or you ask for there to be we use one of the apps for them to negotiate with each other or talk to each other? Is that correct? Did either side want an app? Can they, I mean, the allegations say that he's yelled and screamed and stuff.
I just think we let it ride for a little while until we see
Okay.
how it all plays out.
Does he get to talk to the child on the phone or anything? That's what I'm talking about.
Yeah, he'd like to be able to do that.
Well, Your Honor, I was, in my motion that I filed, I did include a request for app close communication.
I just asked you. Okay, is that what you want?
Yes.
Okay, well, we'll have him to have an app. Set up an app communication, okay?
Okay.
And so that part of your, the motion is granted, the rest will be held in abeyance till 12. If it's not resolved by agreement, but then we'll have a hearing on the 12th, okay?
Thank you, Your Honor.
Right. Thank you, Your Honor. That's all I have. May I be excused?
Absolutely. Absolutely. Owens versus Medical Center of Clinton County.
Good afternoon, Your Honor. Ellen Grimshaw on behalf of the defendant.
Good afternoon, Judge. Honor A. King for the petitioner. Standing in for Mr. Carroll today.
Yeah. I knew right off you were Mr. Carroll. Very good. Your motion is for additional disclosure, is that correct?
That is correct, Judge.
What's the defense have to say about that?
Yes, Your Honor. So plaintiffs here are seeking to compel 2 documents that are subject to Kentucky's peer review and federal patient safety work product privileges. They're also presenting a second argument where they're seeking an adverse inference instruction, but they cannot demonstrate that.
Wait a second, the adverse, inference instruction, is that because you haven't received discovery or what?
That is correct, Judge, and
Okay, well,
that's,
I'm gonna allow discovery, and that does away with the second motion. Okay, I've read the motion. I'm gonna allow discovery on the compliance situation. And, then there won't be an inference instruction. Okay?
Yes, Your Honor.
Okay, thank y'all very much.
thank you, Judge.
Thank you.
Submit an order, circulate before you send it to me.
Thank you, Judge.
McCracken versus Lakeside Boat Storage. Hello.
We can go here for Lakeside, Boat Storage.
Yeah.
Your Honor, we were here last time.
Speak up a little bit.
Sorry, we were here last time on their motion to join a third party. And at that point in time, the court wanted us to come in here today and try to have a plan to join. Well, how was it? The court has had under submission for some time their motion regarding the easement. The court indicated it wanted to try to deal with that, but council's had some discussion between ourselves. And we don't think that's feasible considering the Pulaski Circuit Court case, which involves some of the same parties. And the fact that different councils involved. So we're trying to figure out how to move this thing forward right now.
I believe our motion for partial summary judgment can be ruled upon. My understanding is last hearing, you indicated that if you could see the property, you could better rule on our pending motion, and that you going to the property for purpose of just observing the condition of the property would allow you to rule on the pending motion. That, I think we're in agreement, is okay. And if that is all we envision doing at this time to get a date for you to go observe and then rule, I don't think we have a problem with that. There are a number of other pending issues and motions. We have a motion to add another party. But if Your Honor.
Who's the party you want to add?
Harris
Subsequent owner of one of these.
Well, Mr. Cross has been granted permission to add a complaint against the subsequent owner. They have not been brought into the case yet. I have a pending motion against the subcontractor for subrogation, but if Your Honor rules in our favor on the easement issues, our belief is that this may resolve. So, and we do not technically need ruling on our motion against the subcontractor until May-ish as we get into summer. So my hope on behalf of Lakeside is that we can resolve the easement motion, see what you rule, and then we can address where we're at across the board.
Okay, have you talked about the easement issue with your clients anymore?
Well, yes,
I mean, is there any possible resolution of me going out there and taking a pencil and drawing a line?
Money's a great salve, Your Honor. Beyond that, I mean, it's what they've done makes it just unfeasible for the easement to be back where it was surveyed out to be. But I think we've had mediation.
Okay, let's, who was the mediator?
Who was the mediator? It was an older gentleman.
Retired gentleman. Was it? Did we use?
It was a while ago.
It's been so long. It's been a year and a half ago, I guess.
Yes, Your Honor.
Obviously, it wasn't a memorable experience.
Well, we didn't get very far. Of course, now Mr. Carrick was involved then, and we've got much more reasonable counsel, Preston Counsel and Mr. Pruitt.
And just to go to our motion, Your Honor, just to remind Your Honor of what's pending before you. The question is the easement locked into on the property line, or does Kentucky law allow it to allow what we have done, and does that make it improved it by allowing access from the front to the back of the property?
Listen, Mr. Baylor. Quiet me down back there. Then you go back in the room and want to talk.
All right, we believe it's a legal issue, but understand if you wanted to see for your own eyes what it looks like, that makes a lot of sense.
It really does.
So that's our position, but
I can't go today.
There's a lot of.
Here, let's look at a day.
Your Honor, if it helps, the last week of January, I have a good amount of availability.
Johnny,
how far is it to the, how far?
It's about a mile south of Ryderville, Doctor. It's about 10 miles.
It is very close.
Well, I have a trial going on here Commonwealth versus Stockton, 20th and 21st, right? Let's, that probably a 2-day trial, I'm just saying, let's do it on the 21st, and I'll do it during lunch on the 21st. Can you do it on the 21st?
I cannot, Your Honor.
I can't either.
I have a mediation.
Either want to do it on the 20th?
I could.
I could do it as long as it's noon or further. I have a doctor's appointment that morning.
You're on Eastern time, so that'd be at my.
Actually, yeah, so at noon, yes,
Let's do it at noon.
noon on the 20th. And it's not a very big property, Your Honor, but the thought would be, you could observe what you needed to fairly quickly.
Your Honor, I'd suggest we just all meet here that day and one of the make arrangements to travel down there.
We could all ride in one vehicle. I don't see any reason why. I mean, we're only 5 minutes.
I'm not gonna ride with your guy.
Oh, no, well, I would have him meet us there. I'm talking, I assume you're talking about attorneys meeting.
Oh, yeah, I'd be fine.
Yeah, that kind of thing.
But I'll also be subject to leaving you down there if you don't agree with it, so.
Well.
Okay, we'll, on the 20th, y'all be here available, and we'll run out there, okay?
That'll be fine.
And Your Honor, just to be clear, are we gonna meet you here and then travel over there?
Well, I'm not gonna go out and look for it.
Okay.
So I wanna be here, well, I'll go
Put
get
your
it.
orders in.
Yes, if that's all right, Your Honor, can I tender an order for all that?
Yeah.
And I'll get this to the press and I'll have that.
That'll be,
What's
thank you,
next here?
thank you, Your Honor.
Your Honor, there's a Wilson case that there's.
Well, let me go through this document.
I'm sorry. I just want to-
One thing, Your Honor, if I can just for the record, I want to pass for the record my motion to add Harris Contracting.
You'll
Another
leave
date,
it.
I will be noticed.
Take, yeah.
Thank you.
Wilson versus Sutton.
Leave the manager's tender agreed order on that, Your Honor.
Okay, thank you very much.
And that's all I had. If I'm ready.
Right, absolutely. Republic Finance versus Sharon Powell. You heard anything about that case?
Yes, Judge, this
Yeah.
Julie Gordon here for the plaintiff.
Turn your camera on, please.
My camera on my computer is not working great. I'm
It's
afraid
not
to-
working at all. Okay.
I'm
what do you-
sorry.
What do you have here?
It's just a motion for summary judgment.
Okay, give me a short fact situation, back it up.
Sure. So there was a complaint filed. Let me pull up my document here. I'm appearing as local counsel, so let me pull up my documents here. Looks like there was a complaint filed sometime early in the year. It looks like there was an answer actually in April of 2024. An answer was filed April 10th of 24. It looks as though the plaintiff submitted a request for discovery to the defendant, which is included in the brief in response for the motion for summary judgment. That was filed December 18th of 2024.
What kind of loan did this start out as? What
I'm
is it?
sorry.
Is it a car loan, or what did it start at? I can't find it. What was the underlying debt? Is this a credit card, or what is it?
Let me go down here. It looks as though it's a credit card debt.
Public
Yeah,
finance.
credit card. Yeah, credit card debt.
Okay, is there any defense to this? Anybody here to give a defense? There was we have been making payments to Landmark. They haven't been paying it, plus and it's Sam sharing. Is there anyone here to defend this motion for summary judgment? If not, electronically submit it to us. Okay?
Okay, Judge, I believe that they did.
Okay, well, we'll check on it and we'll enter it if we have, okay?
Okay, thank you, Judge. And that concludes my business.
Bluegrass Stockyards of Albany versus Brett Carver. Hello? Is anybody there? Bluegrass Stockyards versus Brett Carver. We'll pass over.
It's been withdrawn, I received.
Withdrawn, okay, just got an email. Ryder versus Crescent Ridge Property Association. Restricted covenant case. Ryder versus Crescent Ridge. Okay. Well, I don't know. That's- Okay, there's no response to that being called. Kathy versus Connor.
Or have put it on there, it said that they called and said they would reschedule for P12 on the rider.
Kathy versus Connor did.
No, the rider.
Ryder, we'll have Kathy versus Connor. Ms. Coleman,
Oh, yes.
sorry to bother you.
Oh, that's.
Kathy versus Connor. What is this about?
Well, Judge, we passed it to this month. If you recall, we were here last month on our motion to set this for trial. Mr. Connor's attorney requested additional time to do discovery. You gave
This
him,
is the life estate.
yes. And also had indicated they thought we had an agreement. What I thought we had the agreement on was countered with what they had offered at the failed mediation several months ago. And I also have received no discovery requests. So we're just again asking to go ahead and set
Did
this.
he have he never did have an attorney that made it.
Yeah, Mr.
Judge,
Bond.
I'm here. This is Matt Gorman. I represent Mr. Connor on the case.
Okay, what have you done on the case?
Judge, essentially the day before we went to court last time, we thought we had an agreement. Mr. Connor had kind of recited that agreement to me. We had waited for Miss Coleman to put that in writing. She put that in writing. I forwarded it to Mr. Connor, I guess in mid-December, right before the holidays. I didn't get a chance to get with him until last week, at which time he had instructed me that.
You're not telling me anything. You know, I asked you what time it is and you're telling me how to make a clock here. So,
Well, Judge, I was just trying to explain why we haven't submitted the discovery request.
Well, he said 10 days to exchange interrogatories is what the order says. And have you exchanged interrogatories?
No, Your Honor.
Okay, that's all I wanted to know.
And we're just again asking to set it. They wanted to delay setting it because they said they needed to do discovery.
Yeah.
And it's been another month. And
Okay,
there's
we're
still-
not gonna do any, I guess we'll just do like they did in the old days, we'll just let them lay where Jesus flings them, okay? Let's set a date here. The date appears to me, there are a couple issues here. It appears to me is number one, you got a taking of timber by a live tenant. So do you value the timber based upon the value of his life estate by the tables, or is it worse than that? Because if that's the case, everybody that has a life estate can go on and cut timber without, so I think you got a breach that's worse than that. You get than just the value of the timber. You got a breach as to the value of the entire property. Now, Ms. Coleman, do you have an expert there? Have you gotten an expert that's going to testify?
Judge asked you, yeah, we will be presenting them as an expert.
Presenting who?
Well, the individual who was contracted to cut the timber. And let me find that name.
So you're going to say how much he paid for it? The timber or?
Well, and it was, how much he was attempting, I guess, to sell for it and what they thought the value was going to be. And I guess you also
See,
have.
that's different, what the value of the timber on the stuff, then they'll change what the value of the property was because
itself.
of trespass.
We also have an individual who has come out and assessed the property after the timber was cut and is able to give an estimate on the cost to, I guess, repair the damage to the
Or
property.
Diminishing the value of the property.
Yes.
How much do they say that is?
It was, I know we talked about it during the mediation. Cost of the cleanup. I want to say it was maybe $8,000, the cost to clean up the damage that was done.
In the mediation, I don't want to talk about what was in the mediation, but did you make a flat dollar offer that was turned down by Mr. Connor?
Well, there were some other contingencies that my client wanted in place, that we felt like were very reasonable. That seems to be where we have fallen apart. My client has been more than reasonable because it's not about the monetary award for her. This is family property that's been in the family for a very, very long time. So it's about a little more than that for her. So she's been extraordinarily reasonable about the
Was it
financial.
some relief that how can I give relief about that?
Well, I believe it's stuff that is pretty standard. I mean, as far as we're just wanting him to formally agree that he's not gonna make material changes to the property without her permission, which he's already obligated legally to do, as
That's what I
like a
mean.
stakeholder.
The
Like I
only
said,
thing you
I
could
think
do-
that.
The only thing you could do then was file additional action, and hold them in contempt.
Right. So, but, yeah,
But then again, the agreement
I think
they,
the bottom line is they're just, we seem to be at a stalemate. We're exactly where we were as far as being our positions at the mediation, and several months later, fast forward, everyone still seems to have the exact same position. So I just don't think there's any movement or any middle ground at this point.
Well, I'm gonna give a partial, did I already give a partial summary judgment on this? I'm gonna give a partial summary judgment on his right. Well, I know I'm gonna file a new ex parte just offer, but you file a motion for partial summary judgment.
Okay.
And as far as whether he wrongfully cut the timber as a life estate owner. And so the issue will just be back down to what sort of damages that we're talking about.
Okay.
And, you know, I remember Mr. Connor saying at one time that he cut it for agricultural purposes or something like that. But I think he's had more than opportunity to defend this case and present that defense. So I'm going to cut that defense off. And on the next rule day that we have here, which is on February the 12th, if I schedule something late in the afternoon for that. At 2:00.
I have something in Metcalf from 1 to 2, Judge, on that afternoon.
Okay, well, let's start it at 3:30.
Okay.
So, you know. Well, let's start at 3. You can be over here. Let's start at 3. And we'll start at 3:00, and this is about damages. Now, not only I want some law presented that day. Both of you can brief it, Mr. Garman. Both of you can bring it on what kind of damages that they're entitled to. Whether they just, for the value of the timber backing out the value of the life estate, or whether if a life tenant invades and wrongfully cuts, whether the damages to the property or not, and if that's diminished by the life estate. I got a feeling that the damage to property will not be diminished by the value of the life estate according to the tables. I just got that feeling. If y'all brief that issue and then bring your proof on damages on the 12th, okay? And you file your motion for summary, and Scrum, you can do you can be a response to that in so many days, okay?
Yes, sir.
Okay, thank y'all very much.
Thank you, Greg.
Okay, the case is Credit versus Jerry Landers.
Good afternoon, Judge William Rich on behalf of the plaintiff. This is our motion for summary judgment only against the defendant, Wanda Land. Jerry Land has already entered into an agreed judgment, and that's already in the record. This is an action based upon default in a repayment of a retail installment contract and note for purchase of a vehicle. The vehicle was repossessed and sold. The documentation related to repossession and sale and notice to the defendant, that's all in the record. The defendant's answer is just a general denial. We sent requests for admissions, which have not been answered. Those are
Granted.
all right. Very good. Thank you.
It's the judgment. Talent, Serena Talent, is that Rich, right, versus outdoor equipment sales and rentals? Y'all heard anything about that in person?
Afternoon, Your Honor. Nathan Allen on behalf of the defendants, Outcrop.
Okay, go ahead.
This is my motion for leave to file a third-party complaint. Earlier today, we filed a re-notice for that hearing until February 12th, and so I'm just asking you to pass on the motion today.
That'll be fine. We'll do that.
Thank you, Your Honor.
No problem. People's Bank and Trust versus Stacy Guffey. Judge, I guess you're patiently waiting there.
No, thank you,
What do
Your
you
Honor.
have?
How are you doing today? Your Honor, I have a collection case in which I filed a complaint. The defendant, Ms. Guffey, she's here today, but she filed a handwritten response that she was in
And
the
she
process.
has
of
contacted our office and with an ex parte communication, says she's hired the Honorable Gordon Germain and is filing for bankruptcy. And my staff lawyer told her that she needed to be here today
I informed her that if they had filed for bankruptcy, they needed to reach out to you.
That's right.
And let you know.
If they had not filed for bankruptcy,
She has sent me a receipt where she has retained
Okay.
Mr. Jermaine, but that's the last communication I had.
we don't have any proof of him acting on it.
Yeah.
What I would ask the court to do is just go ahead and enter into the judgment, and if she gives us notice of bankruptcy, then we'll stop any kind
I
of
think that's
collection.
appropriate to do. She had her chance.
So
So
she was informed by, from my understanding, she was informed by Mr. Jermaine, she didn't know he would be here today, as he anticipated having filed by the day.
well, what effect will it have on her bankruptcy if she has a judgment or doesn't have a judgment before she files?
Well, this depends on what I guess I would do in the meantime. If I could get this judgment filed as a lien, that would be better for my client.
Yeah. What was this, a loan on a mortgage loan? or what was
No,
it?
it's not a mortgage.
Unsecured.
Unsecured.
God, I hate to do this, with her calling and talking and saying she's hired, but where's he? Where's Gordon? I don't know.
And he's not been retained on this action,
And I've
only
not
the bankruptcy.
heard anything.
She's unrepresented in this action.
I'm gonna go ahead and you submit the judgment.
I've got an order here. The one I submitted didn't have a birth certificate, so I've corrected that on this one.
Okay, thank you very much.
Thank you, Your Honor. That's all I have.
Okay. Mendez Alvarez. Yes, versus. Fernando Lopez. What is this? This is like.
Yes. Oh, I'm sorry.
What do we have going on here?
Your Honor, it's an uncontested custody action. I have an agreed order. Which I had submitted, but I'm happy to have her submit some testimony if you like, but I submitted all the affidavits.
Where is the father gone somewhere or where's
The father is in Honduras. Is in Honduras, so she just needs the sole custody of the child, take care of the child.
You raise your right hand, you swear the testimony about to give is the truth, whole truth, nothing but the truth.
You said jure. Jure, verdad.
She doesn't understand.
Now, I'd asked for a Spanish interpreter. I called your office, called the clerk's office yesterday, and they confirmed that request was made.
Did y'all do a Spanish interpreter?
He just walked in.
You an interpreter?
Mi amigo. ¿Estás bien? Muy bien, gracias. We see each other a lot, Lex.
Okay, you raise your right hand, you swear that you're authorized to act as interpreter of laws in courts of Commonwealth of Kentucky.
I swear,
You do
Judge.
so. Yes. Okay, go ahead.
Ma'am, you raise your right hand?
Levante su mano derecha.
Swear the testimony you're about to give is the truth, whole truth, nothing but the truth.
¿Jura usted lo afirma decir la verdad, solamente la verdad y nada más que la verdad?
Juro decir la verdad, afirmo decir la verdad y nada más que la verdad.
I swear and I affirm to say nothing but the truth.
Glory. Ask her some brief questions.
Thank you. State your name, please.
Sigue su nombre para que conste en el acta.
Delcer Álvarez Méndez.
Delcy Álvarez Méndez.
And what's your daughter's name?
¿Cómo se llama su hija?
Fernanda Lisbeth López Álvarez.
Fernanda Lisbeth López Álvarez.
Your Honor, that's her in the back. Can I ask that she step out?
Yes.
¿Puede salir, por favor?
Okay, that's okay. I see her. She's okay. She's all right. You're
Well,
okay.
I didn't want her to hear the confidential things because she doesn't know everything about her dad.
Well, you want to have her step out back in the room back there. This is public record right here, so I don't know how I keep her or hear anything. We'll step her back out. She'll have to make some extra. Let's move on with this, okay?
Yes, sir. State her name. Who's her father, please?
¿Quién es el padre de ella?
Luis Fernando López Domínguez.
Luis Fernández López Domínguez.
What kind of contact has the father had with his daughter? Has he had any contact with her since she was 1 year old?
¿Él ha tenido algún contacto con ella desde que tiene 1 año de edad?
No, ninguno.
No.
Has he ever provided any assistance to you or to Fernanda?
¿Él ha provisto algún tipo de asistencia para usted o Fernando?
No.
No.
Is it impossible for her to live with her dad because he is homeless and has an alcohol and drug problem?
Es imposible que ella viva con ustedes o con él debido al problema de drogas y alcohol si él tiene.
Sí.
Yes.
And is it true that his mother and sister find him in the street and take care of him?
Y es cierto que la mamá y la hermana de él lo encuentran en la calle y se ocupan de él.
Sí.
Is it in her best interest for you to have sole legal custody of her?
¿Le conviene a su hija que usted tenga la custodia única de ella?
Sí.
Yes.
And as a result, is it impossible for her to live with her dad because of his issues?
Y es imposible entonces para ella que pueda vivir con el papá debido a los problemas que ella tiene, que él tiene.
Sí.
Okay, now you meant to burden as far as doing an order here. You're not trying to terminate his parental rights. are you?
No.
Okay. So I mean, if it was, we'd have to have a guardian ad litem or something else like that. So you submitted an order and I'll sign it, giving her
Eso es lo que
complete
va a firmar la
custody of the
orden.
child with no visitation until he appears in the court to justify something.
Y
Okay?
si
Yes, Your Honor. I'll submit the
padre se
agreed order
presenta,
he had.
puede pedir a disputar su-
You guys have that or you want me to resubmit it?
Was it sent to the clerk's office or where was it sent?
I emailed it. I'm happy to refile it, Your Honor.
Well, we'll try to find it. It'd be good if you send it to us, okay?
Okay.
And you have a provision in there that he shall have no custody rights until he appears in court to justify why he should or something.
I'll have to add that in.
Add it in electronically filed.
Okay, I will electronically file it. Do you want me to send it to your office? Walter? I'll take care of it. Thank you.
Okay, thank you.
Thank you.
Gracias.
Motion for mediation of William Shear and others versus Southern Kentucky Rural Electric. Is this agreed mediation order?
It is not, Your Honor. I just recently entered an appearance in the case, substituting for Daryl Saunders. And, I reached out to counsel for the defendant.
What's this case about?
All the plaintiffs were board members of South Kentucky RECC.
Yeah.
And pursuant to board policy.
I remember the case.
Okay. And counsel for defendant just simply said the client was not interested in mediation. So I filed a motion asking for court order.
You know, what would mediation hurt in this thing?
Well, Your Honor, South Kentucky will undertake whatever the court orders. However, South Kentucky's position in this matter is it's kind of an either or. Either those directors are entitled to the payments or they are not. And so I'm not really sure what mediation can accomplish in an either or situation.
Mediation could accomplish that you buy them off. And that you don't take the risk of losing the whole thing. That's the only thing mediation could accomplish this Sunday. I mean,
Yes,
you feel strongly about it and that you make, with the advice of your clients, make a decision that it's in their bids, not risk the larger settlement for a smaller, so nothing else to be mediated. So I don't see.
yes, I agree. And I have spoken to the current CEO about that, and this was his directive.
Okay, well, I'm gonna order that they enter into force here.
And Your Honor, I would also just mention that we did file a motion for summary judgment in February of 2023, and that was briefed by both parties and has never been, a decision was never ruled on by the court.
Okay, well, now you put me on timely notice that I've been remiss in not ruling on that, and I'll take that seriously. Do the mediation. If mediation doesn't work, I'll be ready to enter a ruling. Okay?
Yes, sir.
While y'all are here, who you been using for mediation?
I told counsel we'd come to Lexington. I have used Pierce Hamlin.
It's always good. Is that okay with y'all?
Yes, that should be fine.
Let's use Pierce and get the order and try to get the mediation done before the next rule day in a month. Can you set it up in a month or?
Yeah.
Judge, I actually am going to be out for a medical procedure for most of the month of February. So if we could set this for motion hour in March, I think that would give us enough time to try and find something.
March the 5th, March the 5th. You know, the way the basketball season's going, not a lot of people want time off during the SEC. or
That's probably true, Your Honor.
Attendance will be down. All right, thank you, Judge.
Thank you.
Thank you. Is there other people here?
Your Honor, there was a case where Mr. Hoover and I were involved. It's,
Is it on the docket?
I didn't see it on the docket. We were told to come back when or Mr. Hoover rescheduled it for today.
Yeah, there was an order entered rescheduling it for today.
Okay, what kind of case is it?
It is a time sharing issue.
I'm not, it's not on my docket.
Case number 1706.
What is the time sharing issue?
Judge, we entered into just as brief as I possibly can, we entered into an agreed order back in June. The because mom raised concerns of the child being subjected to some inappropriate conduct at my client's grandmother's house, who was a foster parent. State police investigated.
Is there any resolution? You feeling better about it?
No, we did get the tape from the Child Advocacy Center, and the child made the same statements there, that this had occurred by this teenage child at his grandmother's home. We're only asking that he not be around that child.
You don't have any objection to that?
No, except, the great grandmother wants to see the child. And we
She can
haven't,
see the child if it's not around this person's
and
allegation.
we've always agreed to that.
Well, then do an agreed order on that, okay? And that child not only shall not be in the presence, period. Shall not just with adult supervision, should not be there, period. And if that's not acceptable, then we'll have a hearing on it, okay?
All right.
Okay, thank you very much.
Thank you.